You feeling well today? Emma? You feeling well today?
May please mention. But I beg to mention item number 17 in the hearing column. The paper,
17.
yes. It's a criminal appeal, madam. Paper book was presented to me yesterday, madam, so I could not go through it. Can it be?
You have received the paper yesterday?
Yes, I have received the paper book yesterday. Can it be on 18th of September, madam? 11th or 18th, whichever is convenient.
No. Okay.
18th of September. I will ask.
May I please, my lord. My lord, I may move one unlisted bail
You
application.
are going back today. Yes.
Yes, my lord. I may move one unlisted intercepted bail application.
Huh?
AB, my lord, for today.
For today.
Yes, ma'am.
That was already
AB two by
Let it-
two, my lord.
Huh?
2 o'clock. 2 o'clock, my lord.
Two? Yes, 2.
2 o'clock, my lord.
Or 2 o'clock.
Yes, ma'am.
Let us say 2 o'clock or 1 o'clock. See. Okay.
I'll also like to mention one antiseptic bill for today. It's an urgent matter. I live there.
My lord, I beg to mention item number 16. This matter may be taken up after 4 weeks. As Malani Senior Consul is out of station. Also have taken permission from the opposite counsel.
Engaged counsel. Who is your engaged counsel? Who is your engaged counsel?
Mr. R. Sonar.
So you are on item number 16.
Yes, Your Honor. Yes, Your Honor.
You are for the appellant or
Yes, I'm for appellant.
name of R. Sonar is not reflected. One name to Sakya, name. Huh? 16.
Item number 16.
What? Item number 16. It's RFA. Or what?
Criminal appeal. Criminal appeal.
Tell me. You are on item number 16.
Yes, Your Honor.
The supplementary hearing, Lordship.
उधार करने के उल्लाय को करने wrong purpose जहाँ आही को करने के जाते हैं whatever नाले उठो ये लगा ना कॉपी for us.
Much obliged.
He is out of station or he is
Out of station.
just after 2.
Not all.
Right.
May it please your lordship. Lordship, I beg to mention item number 3.
Item number 3.
3, lordship. I have just received the copy of the affidavit in opposition. So I need some time for filing of affidavit in reply.
Otherwise also it is fixed on order for actually.
Yes,
So
lordship.
you are appealing for?
For the petitioner, lordship.
for the petitioner.
Yeah, may I pray that this matter may be fixed after 4 weeks, Lordship? In the meantime,
You are
I'll file.
appealing for? You are appealing for sole respondent. So other sole respondent, that means it may be fixed for admission hearing also. Otherwise, it is showing in order column. You have already appeared. And for what you need time?
Lordship, I need time for filing of affidavit in reply, Lordship.
You have filed affidavit in opposition.
Already filed.
Had Mr. Itata, the learned counsel for the petition, also had Mr. O. Modi, the learned counsel appearing on behalf of sole respondent, submitted by the learned counsel for the appellant that sorry, petitioner. That some more time is required to file the affidavit in reply. The matter may be listed. Up to how many? 1 week?
4 weeks, 4 weeks,
4
Lordship.
weeks. It's after 4 weeks.
Deeply obliged.
My lordship. Lordship, I would like to mention item 15, lordship, supplementary hearing.
Yes,
I am for the petitioner appellant. Item 15.
yes.
Oh, yeah. Lordship, matter may be kindly fixed after 4 weeks, lordship. Other counsel is present.
No, you are for the appellant.
Appellant.
And he is appealing for the respondent.
I'm appealing for the respondent.
So otherwise, that day, the date is, you have already taken on 89.
18.
It will be
Yes.
convenient for you on
Yes.
89. Listed on 18. On the request of made by the learned counsel for court, let the matter be listed on 18.
Meet legal lordship. This second appeal, my lord, this has been preferred against the order of dismiss of default, my lord. May I just dismiss for default? May I just give a big background, my lord? A suit was filed, we are the defendant in the suit, my lord. Plaintiff filed the suit for eviction on the basis of a tenancy agreement. Now, there was an arbitration clause in the agreement, my lord. We filed an application before the learned civil judge, section 8 application. But we did, on that section 8 application itself, this suit was decreed. We were not given an opportunity to file our written stay. We preferred in title appeal. In the day when the title appeal was fixed, my lord, we can delay condonation application of 27 days. The counsel met with an accident and he could not appear before the court. And the matter was, the applications were dismissed for default. Thereafter, an application for restoration was filed. That was also dismissed for default. My lord, page 285 is the order. The first dismissal on default is page 273, my lord.
$273.
273. The delay condonation application was on board. Lordship will find this suit is dismissed for non-pressed. According the appeal is also stands dismissed on dismissal of the misapplication for condonation of delay. Thereafter, Malak 274, we file an application for restoration. Though Malak 2 meant by humble submission, this application would have been filed, could not have been filed under order 9 rule 9. So Malak, anyways. And in this application, Malak, the photographs of the damaged car was annexed. Malak. Now thereafter, Malak, this application was on board on 6/5/2023, page 285. So again, the restoration application was also dismissed for. And hence we are before your lordship in the second appeal. my lord. Otherwise, my lord, the substantial question of law would be, they have the code, whether the code below would be justified in decreeing the suit without even on an application under section 8 and taking it as a decree on admission. Now, my lord, this necessarily, my lord, this appeal, if your lordship allows the appeal, it has to go back to the title appeal. Because the first appellate court did not decide the appeal. And my lord, apparently, my lord, it was a fault on the part of the council, my lord, who did not appear in the court. And there, my lord, I'll just rely on a judgment of the Honorable Apex Court, my lord, where the Honorable Apex Court has discussed certain situations. Para 3, my lord. Married. The disturbing feature of the case is that under our present adversary legal system, where the parties generally appear through their advocate, the obligation of the party is to select his advocate, brief him, pay the fees demanded by him, and then trust the learned advocate to do the rest of the thing. The party may be a villager or may belong to a rural area or may have knowledge of the court proceeding. After engaging a lawyer, the party may remain supremely confident that the lawyer will look after his interest. At the time of hearing of the appeal, the personal appearance of the party is not only required, but hardly useful. Therefore, the party, having done everything in his power to effectively participate in the proceeding, can rest assured that he has neither to go to the High Court to inquire as to what is happening in the High Court with regard to the matter when the matter it is listed. It is no part of his job. Mr. A.K. Sangvi stated that the practice has been grown up in High Court of Allahabad among the lawyers that they remain absent when they do not like a particular bench. Maybe we do not know, he is better informed in this matter. Ignorance on this behalf is our bliss. Even if we do not put our seal of immature on the alleged practice by dismissing this matter, which may discourage such a tendency, would it bring to the delivery system into disrepute? What is the fault of the party who, having done everything to deliver and expect him would suffer because of the default of his advocate? If we reject the submission of so-and-so invite us to do, the only who would suffer would be not the lawyer who did not appear, but the party whose interest he represented. The problem that hesitate it is whether it is proper that the party should suffer for some inaction, deliberate omission or misdemeanor of his agent. The answer obviously is in negative. Maybe that the learned advocate absented himself deliberately or intentionally. We have no material ascertaining the aspect of the matter. We say nothing more on that aspect of the matter. However, we cannot be a party to an innocent party suffering injustice merely because his chosen advocate defaulted. Therefore, we allow this appeal, set aside the order of the High Court, but both dismissing the appeal and refusing to recall that order. We direct the appeal be restored to its original number in the High Court and be disposed of according to law. If there is a stay of disposition, it will continue till the disposition of the matter. So, my lord, my humble submission is also, my lord, that the council, when the matter was on board, my lord, the council did not appear. But the application of delay, my lord, that was sufficient for the court to pass an order to condone the delay. But there was a fault on the part of the council, my lord. And therefore, my lord, the appellant should not be made to suffer, my lord.
Your Lordship, first, since it's a second appeal, what are the ingredients that we are supposed to see in second appeal? Section 100 states that second appeal shall lie only from every decree passing appeal, and it has to the High Court has to be satisfied that it invokes a substantial question of law. Now, what is the substantial question of law that he has put forward? In his substantial question of law, he has stated A, that whether the first appeal court erred in law in dismissing the misapplication 19/2023 with order dated 6/5/23 under order 9 rule 8 CPC, wherein the respondent also had not appeared. We have seen that the appellant himself, he had accepted the fact that the first misapplication 7/23 that that was filed by him was regarding the condonation of delay of 27 days, which he failed to appear. Then again, second misapplication is 1923 fix in motion, which was also dismissed on motion stage before even admitting the to even serve the notice, the restoration of misapplication 723 because they failed to appear again. Now, in the order, it is clearly stated that none pressed. What does none pressed mean? Which means that plaintiff has chosen not to pursue the case further. How can a person make 2 times not appearing before the court, he himself after putting forward the misapplication? Now, this second appeal, what is the question of law that they have been aggrieved when it was never decided? Will it be appropriate?
Substantial question
Now-
of law, it might be most probably, they have already stated. Whether the first appellate court has the authority to dismiss the appeal only on non-prosecution, or it has to be disposed on merit. Because if the appeal is supposed admitted for hearing, then it is the duty of the court, it should be disposed of on merit. Actually, that is the main question of law. He filed this second appeal. So, yes.
And-
there are most probably the other judgments also which supports that the dismissal of appeal on non-prosecution can be a substantial question of law in the second appeal. I don't
Yes.
have the judgment presently with me, but there are some judgments. So initially it was thought that it should be in a form of revision.
Yes.
But subsequently, what had happened is apex court had most probably there are some decisions where
Yes.
it has been observed that dismissal can be also a substantial question of law, maybe formulated, and that may be the one of the ground for second appeal. As per my, but if you have any other submission or anything, then can be placed before us. It is on.
On the last
Says-
occasion, it
Because
was,
most probably the substantial question of law are not being formulated till now.
yes.
It is, though the notice was issued to you, but most probably it is not clear. So that is the main issue.
On the last occasion, it was stated that order 41 rule 11 had to be,
Yes, yes, that
Yes.
is, that is to be heard. also.
yes, Your Honor.
So,
As per my understanding, Your Lordship,
yes,
the,
In fact,
The-
order 41 rule 11. In my humble submission, my lord, order 41 rule 11, it is always between the court and the counsel of the appellant. My lord. Order
yes,
41,
but,
yes,
here it
without
is-
hearing the other side.
yes,
but yeah, I have seen 2, 3 other cases also. Here.
Usually the practice is, my lord, it's the counsels are
I
hard.
notice, actually, that is the issue. I mean, without formulating the substantial question of law, appeal cannot be admitted or notice should not go to the respondent. But I don't know, these things are happening here.
Yes.
So, but as they have already appeared, so
Well,
they have the right
yes,
or they
yes.
have the opportunity.
I'm not opposing, but
as per my understanding, Your Lordship, they have filed under order, they agree, they have order which has been passed under application or order 9, rule 9. They have filed it under order 9, rule 8. It should have been under order 9, rule 9, because they should have filed, it would have come on, it should have come under order 43, rule 1C.
What you have submitted.
Appeals from orders.
Hmm.
An appeal shall lie from the following orders under the provisions of section 104. And number C is an order under rule 9 of order 9, rejecting an application for an order to set aside the dismissal of a suit. It should have come under that. Instead, they have preferred second appeal, although second appeal can be entertained as per my understanding only when there's a substantive question of law regarding a decree or judgment. At this point, I don't think this has to be entertained.
otherwise your lordship has seen, there was no adjudication done. So it was only because of the non-appearance, the appeal was dismissed. So what
At
I'm
this
praying
stage, we
for,
cannot go into the merits of the case as such, because they have filed a second appeal. So second appeal, what does it state? Para 5 of my citation, it clearly states that what are the grounds that has to be seen. And we also have to see to the conduct of the appellant, that twice they themselves, they file and then they themselves, they don't appear. In this case, actually, I am the one who has been suffering. I am the judgment debtor. But still, if your honor will go through the order that was passed also by the learned senior CJM court, it is very clearly given why so 6.2 of the arbitration was also cannot be entertained, and to why their statements were also not needed and recorded. It has been clearly given in the application itself. So at this stage, I don't think this appeal, second appeal, can be entertained. This is a fit case to be dismissed.
the one more substantial question of law would be, whether the court below was justified in declaring the suit on admission on the basis of an application under Section 8 of Arbitration Act. Because the scope of Section 8 of Arbitration Act, the court necessarily ought to have referred it to the arbitrator.
No, application was before the court, actually.
Yes. When this suit was filed, before we have filed our written statement, we file an application under Section 8, and Supreme Court has very well confined the scope of the civil court in an application under Section 8. Once the application under Section 8 is filed before the court, because court cannot enter into the merits of the case, court has to refer it to the arbitrator. Now, the trial court, or as we took the plea that the agreement contains Section 8, the learned trial court construed that we have accepted the agreement, and therefore the decree was passed as on admission without even a written statement.
But most probably, on that, the formulated substantial question of law, which is annexed in the present petition or a present appeal memo. Those are, he is raising another issue.
Yes.
That that matter should not be, the court is not justifying to pass an order or decree only at the stage of evidence on the petition under which was filed under Section 8 of the Arbitration Act. So on that issue, if you want to argue anything, then we can give you another date. Otherwise, the petition may be disposed of, or the appeal may be disposed on the admission stage itself. So if you want any hearing date, because otherwise we're going to formulate the substantial question of law today itself.
On this,
He is pressing for another substantial question of law. Apart
Yes.
from this, that the court is not justifying to decree the case at the stage of admission, wherein one application under Section 8 was filed by you.
Filed by us.
filed by them. I don't know, because in the substantial question of law that they have put forward A, B, C, D, E, it is nowhere there.
No.
So I don't think it would be good of law to entertain that now at the second stage
Court can
also.
always formulate the substantial question law based on the argument.
Maybe, but now since he's putting forward, he had other remedies also at that point of time. He should have used that. So now today we are only on the fact that whether the second appeal can be entertained or not at this stage.
We want to make a hearing in this point, or it can be admitted or rejected, whatever. If it is
Yes.
there is no at all substantial question of that, it will be a point to reject the appeal memo. Or otherwise, it can be formulated, we can give you a chance for hearing.
They will obviously they get a chance on the hearing also on this substantial question law, because if your lordship forms this substantial question of law today, On the basis of that substantial question of law, the hearing will take place.
Okay, or yes, any other submission from your side?
I am leaving it on the board, but at this stage, I don't think this has to entertain going around the bush. I'm leaving it on your lordship.
You want to say that it should be disposed of finally today itself? Or
Yes. As per my understanding, my humble understanding, because that was never a question that they have raised. For second appeal, it is very clear given under read with section 100 also, what are the things that we have to go through it. Now, after filing it, after taking time, and then now they are putting forward new. Otherwise, if they are talking about section thing, then your honor can go through the judgment that was passed. It is very clearly and beautifully written as to why and how the judgment has been passed. And the question that they're putting forward also, the answer is also, it is, where is the judgment? Judgment? Yes. Judgment is page number 41. Your Honor, if your lordship will.
yes, your petition under under section 8 was at page.
My lord, will find at page section 8 application. The one I mean. No,
Your Honor,
that application is not on. Court, my lord. Your lordship will find page 40, the page 44 of the trial court judgment,
yes, Your Honor.
page 40,
Para 10,
para 10.
may I read it down?
Para 9 first, and then my lord 10. The suit was accordingly registered.
And summons was served to the defendant, and defendant company GTL Infrastructures entered appearance through the counsel. Para number 10, the defendant number 3 GTL Infrastructure Limited has filed miscellaneous application number 16 of 22 under section 5 read with section 8 of the Arbitration and Conciliation Act 1996 for referring the present suit to the arbitration forum by taking recourse to point number 6.2 of the lease deed dated 1/12/2007 entered between the parties. This court, after hearing both the parties with order dated 4/11/2022, dismissed the misapplication by holding that the arbitration clause of point number 6.2 in the lease deed is only defined to the interpretation or implementation of the provisions of an existing lease deed or for disputes that arose during the existence of the lease deed. Whereas the matter in issue before this court pertains to the removal of the installation from the land of the plaintiff, who being the owner of the land has every right to its peaceful enjoyment. The plaintiff, while relying on the averments made by the defendant in this case application, has filed for judgment on admission as a defendant have admitted to the lease deed. In the instant misapplication 16 of 2022 filed by GTL Infrastructures Limited, it is mentioned that Dishnet Wireless Company Originally, defendant number one was acquired owner by the Chennai Network Infrastructure Limited with effect from 19/7/2022 in pursuance to the order passed by Honorable Madras High Court, and thereafter all the transmitting equipments and or passive infrastructure undertaking of the Aircel entities, including the said lease and lease deed, both dated 18/12/2007, executed by the said DWL, stood transferred to the CNIL. As such, CNIL was substituted for Disnet Wireless Limited as the licensee is respect of the said tower located at the suit land, including the passive telecom infrastructure installed thereon on the same terms and condition as set forth in the said agreement. A copy of the dated 16/6/2010 passed by the Honorable Madras High Court is annexed as Annexure 1. It is further mentioned that the CNIL has been amalgamated with the present company Infrastructure Limited, in pursuance to the order passed by the National Company Law Tribunal dated 13th of December 2017, whereby the infrastructure business owned by CNIL are now owned by GIL. The order passed by the National Company Law Tribunal dated 13th December 2017 is annexed as Annexure 2 of the applicant. While the defendant have prayed for referring the matter to arbitration, they have admitted the lease and license deed dated 1/12/2007 and 1/12/2007 entered between Srimati Omam Darang and Miss Disnet Wireless Company for a period of 12 years. For the purpose of installation and erection, the mobile tower comprising of the shelter, tower, antenna, and other electronic trances, receiving equipments, etc., at a total rent of rupees 5,200 to be increased at 15% after expiry of every 3 years. The lease deed is annexed as Annexure 3 of the MIS application. Order 12, Rule 6 of the CPC lays down the
Okay,
provisions.
These matters has already been discussed by the learner.
Yes, Your Honor.
Section 1, page 146 in my section 8 application.
146.
Page 146. Here we have just said that the agreement that is between the plaintiff and the defendant contains a arbitration clause at 6.2, and therefore the suit is not maintainable and it has to be referred to the arbitrator. Court took this application as an admission and decreed the suit on admission. Necessarily, my lord, the defendant ought to have been given a chance of written statement. And in the written statement, if something would have been admitted and the issue could be decreed on admission, then an issue had to be framed.
Pass the order, most probably it may be primer based to give a short date, but I do not know. It can be possible or not to pass the order today itself.
One.
Otherwise, it will be disposed of as a whole. So I'll make it in civil. If required at the time of the judgment also, if there is substantial question of law as per my view, then definitely it will be framed and accordingly order will be passed. If not at all, then definitely it will be a ground for dismissal.
Right. Otherwise, the lordship is taking up for disposal.
It will be disposed of.
Fine.
Or you, if you want any date of hearing, then you can say.
So
Otherwise,
if your lordship formulates the substantial question of law, then of course it will go for hearing. But if your lordship deciding the appeal today itself,
no, question is that the though it was between the,
I
court
leave
and
it,
the end.
I leave it to your
In,
lordship.
in that case, they will not be here, but they have already appeared, so
Mal.
they have, are good in that point.
My lord.
The substantial question of law, we have already been formulated, these are not the substantial laws as per their submission.
My lord.
So it can be disposed of,
Yes,
if
yes,
you want
yes.
that, any other.
No, no,
date
my
will
lord.
be
I'll-
fixed for hearing,
I perfectly leave it to your lordship.
then.
My lord. May it please, your lordship. My lord, this revision petition is preferred against an order passed by the learned district judge on an appeal which has been preferred by the opposite party arising out of a Kabang decision. I'll just give the brief background, the facts, my lord. On 10/8/2021, some of the petitioners, my lord, they lodged a complaint before the village authority as to that the opposite party number 1 was trying to encroach upon their land. Now, the village authority decided the matter on 13/8/2021, declaring the title in favor of the petitioners. Thereafter, the opposite party, again on 14/8, they tried to encroach upon the land. We went to the village authorities. Village authorities said that you go to the Dirang Sopa. Dirang Sopa is a customary code which comprises of all villages of Dirang area. So we went to the Dirang Sopa. Dirang Sopa decided the matter in our favor. They preferred an appeal before the district judge against the judgment of the customary court on the ground that when the matter was lying pending before the village authority, that is lease village authority, lease village, the Dirang Sopa did not have this jurisdiction to decide the case because the original jurisdiction lies with the village authority, lease village authority. In their appeal petition, they admitted that yes, Dirang Sopa otherwise is an appellate body and Dirang Sopa has a control over all the village authorities which situated in Dirang. Now the honorable, and we filed our objection, and in the objection we brought on record that the village authority on 13/8 itself has decided this issue. So there was nothing pending before the village authority on the date when the Dirang Sopa was taking up the matter. And 25/8, the village authority certified their decision, and that certificate was brought on record in our objection. That was not been challenged before the court, but the honorable district judge, while has set aside both the orders, though that order was never been into challenge, and under the Arunachal Pradesh Civil Court Act, the power has been conferred to the district judge to entertain an appeal which arises from the customary courts. Now, that while exercising that jurisdiction, the court can either allow the appeal or proceed de novo. Now, proceed de novo means the court will proceed with the trial of the case on the basis of the appeal petition which has been filed before it. But the court, while setting aside the orders, have proceeded de novo and directed the plaintiff to file a fresh plaint. So, in my humble submission, my lord, section 26 of the CPC, my lord, upon institution of the plaint, it is an institution of a new suit. And by that way, the honorable district judge has asserted the jurisdiction of a customary court which has been conferred by the Arunachal Civil Court Act. So may I just now take your lordship to the page 20, my lord, the first order that was passed by the village authority. Page 20. May I read? That a complaint was filed before the lease village authority by one Sri Kama Sering and his brothers, stating that a plot of land located at so and so under lease village is their ancestral land, Kharsa, and the respondent Sri Sange Sering is encroaching the aforesaid land with an ill intention. Thereafter, on 13/8, your lordship will note this date. 13/8, a matter was heard before the Lease Village Authority in regard to the land dispute between Kamasering and others versus Sange Sering. In the aforesaid hearing, we had heard both the parties, and it was also came to the knowledge that the same issue was decided in the year 2003 in favor of Kamasering and others present complainant by the then Lease Village Authority. Whereas the aforesaid matter, the respondent was Sri Topu and two others, respondent's father. That in view of the facts, we passed the order on 13/8/2021 in presence of both the parties, and the land in question is belonged to Sri Kamasering and others, and the case was disposed of. So, my lord, this Kamasering is the petitioner, my lord. It was decided in their favor. Thereafter, page 21, my lord. On the next day, 13/8, the decision was taken. On 14/8, they again tried to encroach, and then we approached the Dhiran Sopa. Now, bear it this order, madam. This is the order passed by the Dhiran Sopa. Mail. On 14/8/2021, a complaint has been lodged at all Dhiran Sopa GB by first party, namely Kamra Sering, so and son of so and Pasang Darge of Lease Village regarding encroachment of land located at so and so by Sri Sang Sering, Sri Leki Darka, and Sri Nima Topu of Lease Village. Accordingly, all Gauburas of Dhiran Sopa called upon both the parties on 29th August 2021 and discussed thoroughly the case statement. The Sopa Gaubura have visited the disputed land, and after hearing both the parties, the following judgment has been made to settle the case. As per the customary law of an individual who has possessed cultivable land in the upper side of the hill slope near the water source of the river has right to hold the land up to the reach of river without any boundary demarcation. An individual having cultivable land in the upper side of the hill slope may keep the land barren near the river bank. During the hearing and physical verification, it reveals that the second party has possessed their land far from the disputed land. As per below mentioned map, the first party possessed cultivable land in the upper side of the hill slope since decades and kept the lower portion barren near river bank, and hence the second party has no right to claim the said barren land. Hence, the case has been settled by the all Dhiran Sopa in favor of the first party, and from today onwards, 29 August 2021, second party has no right to raise any claims or objection over the said land in future. A rough sketch has been drawn hereunder to demarcate and settle the disputed land. Now, your lordship will kindly find page 22, the signatories. The village authority who decided the case in our favor at page 20 were also a party, at page 22. Lordship will find in the top right hand column first. Lordship will find that the same person at page 20. He is the head of the GB village. And the other two Gaubura of the Lease Village also were present on the date when the matter was again decided by Dhiran Sopa. Now, your lordship will kindly file their appeal, what appeal they have filed before the Honorable District Judge. Page 23.
21 was filed by you also. 21?
Yes.
Complaint?
Complaint. It was decided in my favor. Again, page 20 was also filed by us, which was again decided, which was earlier decided in our favor. Now, page 23 is the appeal to which they have preferred against the order passed at page 21 by the Dhiran Sopa. Now, my lord will find what were the grounds of their appeal. Page 23 First, my lord will note the appellant name, my lord. There was one appellant. The ground of challenge, my lord, will find page 29, para 4 of laws. Prior to that, I'm not reading because that's the facts of the case.
29.
Page 29, para 4. May I read? During the pendency of the matter case before the Lees Village Authority, the appellant received a parwana from one Lobsang, GB Dirang headquarter, Dirang, informing that a complaint had been lodged by Sri Kamasering and Sri Pasang Darge regarding land matter, and in this regard, the appellant was directed to report before the SOPA on 29 August 2021 at Panchayat Hall, ADC Office, Dirang. In respect of a complaint case, number so and so was registered. It is pertinent to mention herein that SOPA or Dirang SOPA,
Yes.
my lord,
Maybe LCR will recur in this case, my lord, whether LCR will become my lord or not.
No, because it was in most probably in order column actually. So that is there. So you need the.
Not my, maybe my lord will recur, my lord. Ultimately, this record is by him and me, my lord. This is not the record of the court, my lord. Normally in CRP or my lord, an appeal, my lord, record of the lower court will be required.
So obviously, most probably record will be required, I think.
otherwise, my lord, the challenge of
Otherwise, my lord, issue is simple, my lord.
Issue is
On is a
simple.
law, on the law, my lord. I have no objection, my lord, my lord, heart, my lord.
basically a very only one question of law, whether the honorable district judge, while deciding an appeal arising out of a customary code, if has proceeded with the proceeds de novo with the case, can the honorable district judge direct the parties to file a fresh plea? Because section 26, it says, my lord, upon presentation of the plea, this suit is instituted. So this doesn't anymore becomes a de novo proceeding. It is a new suit. And by this way, district judge has usurped the jurisdiction of a customary court and the original civil jurisdiction, which lies with the civil judge senior division.
So in absence of otherwise, most usually all relevant things are here.
My lord, appropriate my lord procedure would be, my lord, LCR would be required, my lord. Otherwise, my lord, this is any order by this honorable president, my lord. If without LCR, my lord, pass any order, my lord, that will become a president.
Otherwise, if something's,
My lord.
I mean, maybe they're.
Maybe, madam.
In that case, it may be difficult.
That will be appropriate procedure, my lord. Calling the LCR, my lord.
Otherwise, in the earlier orders, whether the LCR was called for was.
Not sure, my lord.
No,
Not sure, my
No,
lord.
not at.
Because the facts the records which are available before your lordship was never been disputed by either of the parties.
No, my lord, that is the relevant fake, my lord. The very initial fake, my lord. I would sorry to say, my lord, it is misleading fake, my lord. The very initial fake, my lord, put forward by the petitioner, my lord, is a misleading fake, my lord. I'm sorry to use the word misleading, my lord. We'll reply on that appropriate time, my lord.
Misleading, you're saying.
Misleading, my lord.
Achha.
Fake, my lord.
Let it come, the record may come, record may arrive.
But I don't know why my friend is saying so. There was, your lordship will peruse the order sheet. It was never a case of the opposite party that the records are not available before this court and that it cannot be decided.
No, no, my lord. Today also I am not saying so, my lord. Today also I am not saying so, my lord.
My friend is alleging that I have.
One, I don't know, one office note is here on 5/8.
Yeah.
The LCR not yet received till date.
Well,
There was an odd,
I-
I mean, note by the registry. Most probably record was earlier called for, I don't know, because records not yet received from the district and section judge Port Bomdila, in the earlier order.
Well.
And that in subsequent, on 5/8 also, it is stated that LCR. has
I have
not
no
been
problem
received.
my lord, if the records are called for.
So LCR of civil appeal numbers also not yet received by the so and so. So record was earlier called for, I think. It
That
was
would be the
called.
appropriate procedure, my lord. I am not saying, my lord, in absence of record also, if my lord pass, my lord, any order, my lord, I am not agreed, my lord. I am ready, madam.
He is not submitting that calling for a record is a misleading one.
No.
He is submitting that the submission you have made.
Yes, my lord. Very fake, very initial fake, my lord. Is misleading, my lord.
Not the record, not the record.
Not the record.
So from Bomdila, when can it be fixed from Bomdila? Because record is not yet received. Though most probably reminder was also issued, I think so. I'm not sure about it, but reminder may be issued, I think. But till now, not yet received.
Minimum, my lord, at 3 weeks will be required.
3 weeks will be required. Heard Mr. G. Deka, the Learned Counsel for the petition, also heard Mr. L. Parley, the Learned Counsel, appearing on behalf of respondents. You are representing all the respondents?
My lord.
My lord, be cautious.
Oh, sorry, be cautious. Be cautious. Be cautious, huh? And in other two matters, what the name of the council is showing as Gautam Deka.
In the other two,
You are-
my friend.
that's correct. Be cautious, so and so, and from the office note dated 5/8/2023, to visit the SJ is not yet received. In spite of issuance of reminder, let the fresh reminder be issued. To the concerned court to, for the LCR from the Court of District and Session Judge Bomdila. The base table to the needful, let the matter be listed accordingly to 3.
My lord, can it be on 18, my lord? I'm coming back for some other cases. By then,
18, no?
18th of September. I think
In the other two matters also.
Yes.
18th of September.
Obviously.
Oblige.
Your Honor, matter may be passed. My senior.
No, it is just a second, it is in order column actually.
Yes.
So let us see whether the state has already appeared. Regarding in regards to the other, whether there is any service, we will see.
Your lordship, this is a joint petition, your lordship. This is a joint petition, your lordship.
Oh, joint petition.
Yes, the matter has come because an IA was filed, your lordship. Yes,
I Oswald.
yes, what has happened, your lordship, was that in this matter, in the charge sheet, different persons' name were reflected and the parties were different, your lordship. Now subsequently, why this IA, a corrigendum was issued by the IO to the CGM, apprising the court that the name in the charge sheet has been wrongly reflected and the name of the main accused has been corrected, your lordship. If your lordship will see the IA, your lordship, page number 13.
Corrigendum was submitted by the IO. before the
IO,
council
IO.
yesterday.
Yes, your lordship.
That this body actually wrongly was. sent.
Yes, the name of some other persons, instead of the accused name, some other person's name were reflected in the charge sheet. That corrigendum was corrected subsequently, your lordship.
And then what happened?
Now they have come before this court with a mutual agreement of settlement, your lordship. The first objection that was raised on the first day was with regard to the different name in the charge sheet and the parties in the petition as well as the parties in the FIR, your lordship. Now via this IA, they have brought into record this corrigendum issued by the IO, your lordship.
So now the entire has to be,
Yes,
they have filed the earlier petition
Yes,
on the basis of the charge sheet filed by the IO
the IO
earlier, but
Yes.
now the names are already been,
changed, your lordship.
then what is the position from your side?
Your Honor,
Now, by this,
No.
you want to,
No, if I may, your lordship. While the first charge sheet was filed, your lordship, they have annexed the charge sheet in the main petition, your lordship.
Mm.
The name reflected in the charge sheet
Mm.
was not of the accused name in the FIR. They were of different person, your lordship.
different persons now.
Now, during the pendency of this IA, your
They
lordship,
have come to know about this.
yes,
Mm.
the clarification was sought by the CGM to the IO, your lordship.
Mm.
Now, the IO wide corrigendum has apprised the CGM court that it was inadvertently, there was a mistake and the name has been changed in the subsequent charge sheet. Your lordship. Your lordship will come to page number 13 of the IA, your lordship.
Hmm.
Your lordship will see that
But inadvertently and by mistake of last break of the name of the accused firm, Tana Kapoor, present Tana Limited, entered instead of, actually the name should be Srimati Lise Ada, Likha Apo and Srimati.
Likha, yeah.
Yes.
Yes,
and
yes, Lord.
okay,
So these are the
Yes.
actual.
actual name of the accuser.
But in
Now in the main petition, your lordship, these are only the person, your lordship.
Oh,
in charge sheet, Your Honor, page number 26, the investigation officer has wrongly reflected.
but the petition, they have, they named the person who should be in the charge sheet. actually.
Yes,
Yes.
yes, they, all of them has actually filed this petition.
Acha.
Even the agreement has been done accordingly. Your lordship.
So this application has been filed on the basis of mutual settlement made by parties, Your
So by this, the present what is your prayer now?
Honor. Prayer is that Lordship,
That-
Because already they have already named the person,
Yes,
actual person. accused
yes,
person.
yes.
So what is your prayer? Here you were praying for?
yes,
In the
Lordship, prayer is that Lordship, this corrigendum, this documents may be admitted by this court and after that, Your Honor, this,
Now the corrected, the charge sheet has, you have
Yes.
filed this one.
yes.
No, no,
Where?
No, Your this copy we have obtained CTC from the London Judicial Magistrate UP Lordship. So
No, this
this,
order, this copy of the page 13 you have obtained.
yes,
Now, on the basis of the page 13, whether the IO has came, I have come before the magistrate and make the correction, the necessary correction. to
yes,
the
yes,
charge
this part has been already given.
So after that correction, have you procured the charge sheet,
Charge sheet,
copy of the charge sheet?
charge sheet already we have obtained. Yes, it's
Where?
trial before Lordship CGM. Charge
No,
sheet Lordship we have annexed.
I am not on there. The present petition, when you have filed, you have correctly named the accused persons. It's okay.
Yes, that's
But later on, it has come to the notice that the charge sheet actually accused persons were not in the charge sheet and some other persons were named in the charge sheet as an accused, isn't it?
Yes.
So after that, they corrigendum issued by the so and so. Most probably the correction was made by the IO. Necessary correction has to be made by the IO in the charge sheet column, name of the accused column. So have you corrected that charge sheet? Because it will be required, no?
Lordship,
I think that those new charge sheet with the changes of the name has not been made because if your lordship will second paragraph, if your lordship will see, the honorable court is free to read the name of the accused as per column number 11 from A1 to A4. I believe
Where
that,
A1 to A4.
yes.
Hmm.
I accuse number 1 to accuse number 4.
Hmm.
I believe that there is no changes made in the charge sheet already been submitted, your lordship. Only via this corrigendum,
corrigendum.
the court has been apprised of the same and there is a clear prayer that the honorable court is free to read the name of the accused.
Yes. And the problem is that Lordship, earlier this, the main charge sheets, IO has wrongly reflected 3-person name,
No, that is.
including this petitioners, Lordship, applicants. So because of that, the case is,
Including these petitioners were not included.
new charge sheet has not been filed, only this corrigendum documents has
If I
been
may-
submitted before the
If I
CGM.
may, your lordship,
That's for only.
if I may, your lordship, if the LCR is called for, your lordship, we'll be well aware if the same has been changed or not, lordship.
Obviously.
So lordship,
Because we are going to dispose a petition where the name of the petitioners were not in the charge sheet. In
the
that case,
petitioner
it
name
will
is
be-
there in charge sheet, Your Honor.
Huh?
Petitioner name is there in charge sheet, in the original charge sheet also.
That they were not brought in the column, accused column, I think. Their names were not in the accused column earlier.
Lordship, may I clarify, Lordship?
No, I have already clarified. The matter is that some of the persons named in the accused column of the charge sheet,
Yes.
actually those are not the actual accused,
Yes,
isn't it?
yes.
So subsequently, a corrigendum was filed. before
Filed by the
panel
investigation.
proceeded, One, there was so and so.
Yes.
But here we are dealing with the charge sheet where the name of the present petitioners were not in the charge sheet. So why don't you, we have to, most probably LCR should be called, otherwise it will be a chaos not passing the order. Because names of those persons are not in the charge sheet. So if the LCR reflects that this one has already been accepted by the learned CDM or learned whatever court. And then in that case, there may be a reflection in the order from that will help us.
Yes.
That part has not been done.
In fact, if the CGM has accepted this
Ah.
corrigendum and accordingly an order has been passed changing the name, all those need to be looked
Yes,
into
it
it.
should be there because your petition is on the basis of a
Yes.
charge sheet where the petitioner's name were not at all in the charge sheet as an accused column.
Uh,
That is the reason.
Lordship, page number 13, this corrigendum has been already
Yes,
forwarded
yes, I
to
have
CGM
been-
UPI.
Yeah, I read this one.
Yes.
So
So
it can be called.
that can be,
That's so and so, the LCA we call for. Full stop. It will in the main suit, you read the LCS. Is still going on, the procedure is
yes,
scan copy of the LCA be for along with the present status report. And this one, let the matter be, has to come from which place?
UPI.
You-
Because scan copy was already there. I
It's
think
already
earlier.
yes. Only
There means it was the earlier,
earlier,
Yes,
earlier, with the earlier chart sheet,
updated
Yes.
LCR. copy.
not updated.
Yes.
So ladies can scan copy of the updated scan copy of the LCR be called for so and so. Letter may be fixed after 2 weeks. And the I may be disposed of, heart so and so, so and so. This is an application filed by the petitioner. Praying for allowing the corrigendum documents submitted by investigating officer of New Delhi Police Station, so and so. Police station, officer of police, PS case officer in PS case number 32, 2022 of charge sheet number 42, 2022, dated 28/11/12/2022. Considering now it is submitted that inadvertently the IO has reflected the name of some persons which are not the accused in the present case. And accordingly, he filed an corrigendum before the learned CGM
CGM UPI.
UPI. UPI. But I find it proper to accept the petition. The said corrigendum subject to condition that were subject to the acceptance of by the learned CGM UPI. Accordingly, I find it necessary to call for a up-to-date scan copy of the LCR. HCL and which will also be required in disposing the connected criminal petition. However, with this above observation, the IS stands disposed. This is not required further. So we'll.
Deeply.
After 1 week, 2 weeks. How many weeks I have fixed? Let the matter be listed after. Main petition, it is disposed of, otherwise, other one is disposed of.
May I please, Your Lordship?
See, 4 to 14 are most probably all are connected.
Connect.
Yes, all are.
Connected means.
Connecting
if-
similar matter,
If
all
your
are.
lordship it decided one case, then the argument of all the cases will be same.
but facts and the figure will be different.
So all the cases,
Point
for
for
appellant, you are representing in all matters.
all the matter. Point for determination of one cases will be result each and every case, but judgment is to be delivered independently in which cases.
But in that case, my personal problem is that I'm only for this week only, so I have to carry all these records to Guwahati. If the matter would have been placed on the last week or the first week, because I was here for 3 weeks, it would have been made convenient for me, so
My lord,
personal inconvenience on my part actually.
my lord, may I pray one thing, my lord? Can we start, and if your lordships comes on the next
No chance.
Because
And-
this matter was once
because I have to come from
Our
Guwahati,
lordship-
Yes,
and
I know.
that's why
it was already part had long back by our
Okay,
lordship
that
Robin
is the
Cook.
reason, that's why I
Again,
do not want to keep it on part heard matter, because if I suppose, if I stay here for 4-5 weeks, suppose, then it will be for part heard matter.
yes,
But we cannot say at this stage when my next bench will be here at Arunachal. So that is the one point.
I got your,
Otherwise, suppose,
because
because it was, if it would have come on the first week, then definitely it could have been heard the entire
yes,
matter.
yes.
Because most of the matters, mostly you are representing, that is easy for us, and he is representing the other side. But the question is, that matter only I am saying, because I do not want to keep it in part ready. Otherwise also it is a matter of 2019, already delayed matter. So.
All right, then, lordship, and next day we can, as per
For
convenient of
last
my other.
next 2 weeks, I'll be at Guwahati, and then maybe or may not be, I cannot say at this stage. That is the main issue. Because 1-2 matters, almost, the facts are, why facts are not?
facts will be same,
Facts will be same.
facts will be same, figures will be different,
Okay.
figures will be different.
Whatever, then in that case, if it could have been heard on the last week or the other week, then I could have started dictating this petition. Otherwise, 14 numbers of matters, it will be.
And
inconvenient for us.
after losing both the court, I will have to take time. I lost in both the court below.
Oh, man, it was the second appeal is
Concurrent-
against the concurrent decision.
Concurrent decision,
You will take time.
yes.
Yes,
And
yes.
apart from that, the first appellate court have not decided on merit. It decided only on the point that it has been wrongly decided that since there is no substantial question of law involved, so appeal is dismissed by the first appellate court. And under provision of 1964. And 96(4) is not applicable in this case because suit value is more than 25,000. If suit value is less than 25,000, then that may have come, because in that case, second appeal is not maintainable. So in the first appellate court, that point can be entered into, but here in this case,
So first appellate court.
Court should not-
dispose
should
of
not.
this
And
subject
on
of
merit-
law only.
Lordship, that is the, his
No, no, no.
submission only.
No, no,
It's
not
not-
submission.
no, no.
Yeah,
Yeah.
but on merit,
But otherwise also.
But other
the
judgment is
has
otherwise.
to be, merit has.
On merit, on merit, it is.
Or the first appellate court.
first appellate court merit has not entered into.
If we,
That
Nothing.
if we go
that may
through
be
the
one issue,
judgment.
I do not know, but.
No, no,
It is the
it-
first appellate court to,
First appellate,
hear the matter merit as well as.
Yes.
law. Then that
but
is-
merit has not gone.
If we go through the
Only-
judgment, then
only-
only
only-
whether
only
it is a dispose on merit or based on
As per
96(4).
you, merits were
No,
also
no,
discussed.
that may be as per him, but I will show from the, it is on record,
Whether
whether it has gone in
Yes,
merit
will, as per you, what will be the convenient date for you?
7 or 8.
7 or 8 of
September.
September.
make it seven,
Maybe
lordship.
7 or 8, maybe my bench may be here also, I do not know at this.
Ah.
At this stage, it is not possible for me to say, but anyway. Yes, 7 and 8, do you have any?
Seven.
7.
Yes.
You have any other matter in 7 on 7?
I don't have any matter, but in 7, and 8, I will be here because Central Administrative Tribunal Circuit Bench will be sit here on 7 and 8. On that day, I will also representing in that court.
Then we're fixing on 7.
Oh, 7 years loss.
And this circuit bench will sit in UPR,
So then it will be convenient for
Yes,
you
yes.
on B7.
7 and 8.
I am always here, no problem.
Like your
Really, sometimes only I used to go out.
Metrobus must be really interesting.
I thought
but
that I
not
will
like
start
that.
today and it may be
Because this
finished.
is a long.
So otherwise, also ready. If 1 or 2 was there, I could have carried the thing. But the entire bulk of thing is also we confirm from us. And part hard will definitely affect you also, because I don't know when that should be there or you have to wait.
No, part hard will be problem because earlier also it was
Yes,
part hard,
part hard.
but when matter was hard, it
Or it
found
can
that
be fixed day to day. basis.
record has not come.
Yes.
So ultimately a record was called for, then it has been
Yeah.
released from part hard.
Actually,
Or
we were
maybe
discussing
half,
that
day
if
to day basis also, if
Yes.
on second half, especially on second half,
Yeah.
from 2 to 4, it can be
Yeah.
if on day to day basis. But
We-
I'm on my part also, I'm going to
Yeah.
never needs. So.
we
let
were
us
also
see.
discussing that at least my brother pass would be complete today and tomorrow I can continue. But as per, so Lordship is not convenient for her.
It's not
Oh,
convenient,
yeah,
it's
it's
not
all right, no
convenient for
problem.
me. At
We'll
least
try
for
on the
1 week.
next.
Yes, 4-5 days it have been remained, then
Yes.
definitely it will be a convenience, but otherwise it may be not.
Yes.
So for my inconvenience, I'm going to.
No
Yes, all
problem,
right, no
no issue.
Otherwise.
No, sir.
We don't have any
I'm
issue.
not feeling good actually for adjourning these matters. Anyway, it will be fixed on 7th and 7th of September. Let us see if I may be present also in that. It might be
Yes,
fixed
if
there.
required on 8 also I will do. If
Yes,
7 and
it's
8.
definitely, it may be required also,
Yes,
because
yes.
it may be continued.
Yes.
On 7 now.
Yeah, all right.
Much obliged.
Item number 18. Yeah. MSc. No, Nigeria for 1920 is a good one. 1920 yes. 1920. No. 1921. 1920. Oh, কি বানানো আছে 18? 18? Okay, 18? You are on 18?
Yeah, 18.
For the appellant, you are for the appellant?
Yes, your lordship.
Yes.
Your lordship, today the OP number has to be file objection
No, it is.
Regarding
it
the
is
ma-
listed in the hearing column only. What objection?
regarding the appeal, lordship. Regarding the appeal, your lordship.
Who is representing the OP?
OP number 2,
OP number 2?
insurance company yours.
Insurance company.
Item number 18.
Yes, we are on 18.
Yes. For 19.
Company is response number 2. The insurance company is response number 2.
Yes.
Yes. Respondent number.
Who is representing the company?
I.
So I'm putting that one.
You are for the response number 2.
Yes.
A New India Insurance Company.
Yes. So they said that in the insurance policy. that was
No,
issued-
you have to submit written objection today.
Yes, I was in the mail.
or whatever, main appeal.
Yes.
Then,
No, sir, I need to receive instruction. Instruction in the sense of like, no, sir, there has been some clarification regarding the insurance policy. Because in,
they have annexed the insurance policy here.
yes, no, sir. There has been, Rosib, in some other columns, the limited liabilities for the persons employed for operation and they have paid an extra premium for their loss. But in the other column, Rosib, limited liability for paid driver, conductor, cleaner employed for operation. They didn't pay any extra premium. So in that case, Rosib, a clarification with regard to the, from the company is yet to be received, Rosib. On that part, Lordship, I will be filing the objection on this.
Which order you are directed to, or you are asked to file the objection? Is there any order?
On the last date, Lordship.
On the last occasion?
Yes, there are 27 laws.
Yes, any other submission?
Lordship, the reason this appeal was listed today is for hearing on the IA. On the day of the motion, a stay was granted, suspending the execution of the award. So this hearing today, Lordship, was fixed because to adjudicate whether the stay should be vacated or it should be continued. On the last occasion, the appellant were directed.
Falco on stay matter?
Yes, Lordship, because they have neither deposited any money for procuring the stay. The stay is stay. They have received a stay from this honorable court on the motion stage, Lordship. But
No, you are the claimant.
no, Lordship, they are the vehicle owner. I am the claimant, Lordship.
Oh, you are the claimant.
I am the
They are the
claimant.
owner.
They are the owner. I am the OP number one, Lordship. Here. in
Owner was
person.
directed to pay, I think.
Yes, Lordship. So now they have preferred an appeal and they have procured a stay. So now due to the stay that was given on September 2022. Now we are in July of 2023, Lordship. So I've been unable to, now they are not disputing that one of them has to pay because they are saying that there was a valid insurance company. But they are saying is that they have violated some conditions, so they are not liable to pay. So one of them will have to pay, Lordship. But in the meantime, I am the person who is suffering, Lordship. For the past nearly 1 year, I've been unable to execute the award because of the stay, Lordship. So this date, Lordship, was they were to convince this honorable court whether why the stay should remain, Lordship, because I believe whether it was reflected in the order or not, whether orally it was there that on the next day, if they don't pay the money, they don't amount deposit any, or they don't convince this honorable court, then the stay would be vacated, Lordship.
Stay was passed in IA 195.
Yes, Lordship.
195.
195, Lordship. During the motion stage, Lordship.
On 20/09/2022, Your Lordship. In the order, there is specifically speaking about the Your Lordship, judgment and the award dated 23/8/2022 passed by the learned court below. Shall remain suspended as interim measure till objection is filed by the present applicant. Till the objection is filed, Your Lordship. So till today, none of the respondents filed any objection regarding the vacation of the interim or regarding the issue I have raised in my appeal, Your Lordship. None of the respondents filed yet.
Lordship, our objection is.
They has to file.
oral, Lordship. We did not intend to file a written one. That is why we had been appearing and we had been submitting that we will not be filing a written objection.
What about you?
No, sir, I am concerned with the main issue.
You are concerned only with the main appeal.
Yes, because they are challenging the liabilities.
Now, Lordship, if they had procured and stay, now this is akin to a money decree, Lordship. So they have procured a
See,
stay.
the question is, till the objection is filed, the present application, the judgment ever so and so will be stayed
Yes, Lordship.
as an interim measure. But thereafter, for depositing of the, you deposit, you have filed, whether you have filed any IA in that regard. Those stay was passed, no order on deposition was passed by this court.
Yes, Lordship.
So there was no any interlocutory application
No,
from your
no,
side.
no for
And
payment.
now you are only objecting or. what
The
you
stay,
said,
regarding the
that
stay,
stay
Lordship.
should not be there.
Yes, Lordship.
Yes, anything to say?
Because Lordship,
Now,
they
the
are like,
question is a bit different when definitely there should be a payment, a deposit of some, at least 20,000-25,000, whatever. But the question is most probably they are, as they are from their side, I'm saying, they may be that they are not supposed to, they are not liable to pay the compensation as their vehicle is duly insured under the insurance company. So entire liability goes on them. So maybe that may be the position. So why don't we can hear the entire matter also. In that case, why you file your objection then?
So I'm yet to see the instruction, Lordship.
Otherwise, Lordship, only the simple issues, only one issues. Whether the OP number 1, who is the insurance company, and whether the owner of the vehicle is liable, Lordship. And my contention is that I'm not liable yourself. I have answered with the insurance company, which is the OP number 2, Lordship. I have duly paid every terms and condition as given by the OP number 2 for my vehicle, which has been used in the site, Lordship, where the OP number 1 incidents has been occurred and dead accordingly, Lordship. So only simple one issues, your Lordship. I have paid everything duly paid, answered with the insurance company, Lordship. So I'm not liable, Lordship. But the learned court below has made a manifest error, your Lordship, while differentiating the term driver and the operator, your Lordship. The learned court below is opined on the term of the driver, Lordship, not in term of the operator, Lordship. In the basic understanding, your Lordship, the vehicle which drive or operate through the, yes,
Okay, but the question is that they have not taken instruction, I think. So but it was most probably reflected in the order itself that you should file your written objection.
Lordship.
So, and accordingly, as per your prayer, most probably time was granted for submitting or furnishing the written objection. But till today, you have not able to take any instructions from the authority concerned, or now you can file the, able to file the written objection.
Lordship, the issue here is that, Lordship, because it just given in shorthand, Lordship, OPN. So whether it is the OPN stands for operation or the operator, that has to be determined first, Lordship. And
That is there,
yes.
that is why you want to time was
Lordship may allow some
granted to
important-
take instructions from, and accordingly you should file the written objection also.
Lordship.
And in regards to the vacation of the interim, anything to say from your side?
yes, Lordship. On date 20/09/2022, at the motion stage when I filed for IA
There
for
was a stay
suspension,
order in
yes,
January.
yes, your. And there is a, your Lordship clearly speaking that the field of objection is filed, your Lordship.
They are
So
not
since
filing
today they
objection
have
written
not
form,
any file.
They are filing their objection verbally only in the oral form, not in a written form.
There has to be satisfied this code.
Because Lordship,
Yes.
there is only one.
How
policy,
much?
3-page policy. Now, the only thing is to be adjudicated is whether that one particular column, it will cover the driver or not. For that, they have, the parties are taking 1 year. I
Lordship,
am being
it's
prejudiced
not my
for 1
fault.
year. There is one
Lordship,
column.
that's
Lordship.
not my fault.
It will be explained either by the insurance company, either by the owner. But they need to explain this. Lordship, this is the only thing. Factually, there is no dispute. Only the policy is being disputed. Now, for a 3-page policy, Lordship, 1 year is more than sufficient to understand, Lordship.
That's why my sincere submission before this honorable court. If the OP number 2 is, if they file their objection, very next day, the matter can be disposed of, your Lordship. Only the single issues has to be determined by this honorable court, Lordship.
And Lordship, we had been endeavoring to
So
dispose of
matter
this
is not pending
along
because
with
of
the
me,
IPO
your Lordship.
as well.
Because with the
We
OP
plan to
number
dispose.
2, their interappearance a long back, but still they are seeking time for the filing of the objection, your Lordship.
Within 1 week it can be fixed?
Lordship. Yes.
Otherwise, I am also very much concerned about the OP number one, Your Lordship, who is the
Claimant.
claimant in the case, Your Lordship.
It is the death matter or injury.
Death.
Death.
So definitely.
Yes, I am very much
Suffer-
concerned, Your Lordship. But is the OP number two who is not filing the objection? Otherwise, if maybe dispose of one or two hearing, Your Lordship, only one
No,
issue has to
hearing
be.
is written, why two hearing? Only one, simply one.
Yes, yes, Your Honor. Only one issue has to be settled by dismal court.
Liability, whether it's.
Yes, yes, Your Honor.
I mean, insurance or it has to be paid by the owner.
Yes, yes, Your Honor. That is the issues only.
In the trial court also in before member city also you took that plea that
Lordship,
you are not liable.
yes.
So then-
Otherwise, Your Lordship, if they are not intended to file any objection, it may be recorded the next day, the case may be disposed of, Your Lordship.
So we are not going to give you not more than 1 week. So within 1 week, take instruction file, or if you cannot file the written in the written form, then probably submission will go us. It will
Lordship,
be recorded by the court. No, because policy is already here with us
Yes.
in the record itself. So what are the conditions policy, whether there was any violation of the policy, that will be decided by the court itself.
Lordship.
So it is submitted by the Learned Council for the respondent number two so and so. That some more time is required to take instruction from the authority insurance company. But considering the order on the passed by this court dated 27/2023. One week is only 1 week's time is given for the OP number two / insurance company to file written objection, and as the matter is pending since long. And the payment is also the Learned Council for the OP number one. Mr. Galu, they also submitted that the matter is pending, and still after a lapse of 1 year also, due to the stay order passed by this court, the case is not at the execution stage. Considering the submission made by the Learned Council for the OP number one and all other aspects of the case, let the matter be listed after. Do you want any date fixed?
Lordship, after 1 week.
List after 1 week. And registry is hereby directly to list the matter accordingly after
16.
In both the matters will be
Lordship.
same, more or less same order.
Can it be on, there will be fixed date on 16th, Lordship? It will be within 1 week,
16 will be
1 week.
convenient for you. Because 15th August,
Yes, Lordship. So Lordship, we are all local council, I believe, Lordship.
local na. Okay, then it can be 16th August is Tuesday also. Then what?
Wednesday.
No, Wednesday.
Wednesday.
Okay, 16th of August. And if it is not possible to file any written statement, then you file or a verbal submission, yes.
Highly obvious.
Please, my lord. My lord, this is the joint application filed by the victim and the accused in connection with the turnover PS case number 301 of 2022, whereby my lord, the case was registered under section 336 IPC, read with section 27 and 30 of the Armed Act. My lord, on the last occasion, my lord, in view of the argument advanced by both the party that we have already submitted the relevant.
So yeah, argument was already there. Why?
Not
Order was not
completed,
passed?
my lord, yes.
Order was why order was not passed?
Oh,
Your lordship,
No, matter was
was
heard.
not-
Matter was heard already.
yes, but
Why-
that was yet to ascertain, my lord, yet to ascertain the single point that whether this, my lord, petition can be granted under the, my lord, Narendra Singh, my lord, as we have report, because this is the petition of both the parties on
Disposed of for what?
mutual agreement.
Oh, the other petition was.
it was not disposed of, your lordship.
Huh?
Only their submission and our submission was recorded, but matter was not disposed of, your lordship.
Yes.
We raised our respective objection
So otherwise, what was the section where the case was charged sheeted? 27 arms.
Not charge sheeted yet, your lordship. The investigation
It's
is,
still under investigation.
yes, it's yet to be charge sheeted because for want of prosecution sanction, because Arms Act is there, your lordship.
Yes. So it
Offense.
is still under investigation.
Yes, your lordship.
So far no charge sheet has been made.
Now case is
Fine.
under section 336 IPC, related section 27(1) and slash 30 of the Arms Act.
Yes, your lordship.
So at the stage of investigation, we have the petition number 1 is the victim or accused?
Petitioner number 1 is the victim, madam.
1 is the victim and
2 is the accused.
2 is the accused, in a sense, one amendment was there. Like, see, Yombum,
Yombum, he is the police personnel and the information FIR has been registered in the name of this person. In fact, my lord, what has
so
happened?
he is now included as a respondent number 2.
Yes,
However, the state is representing state and
In last occasion, the court has indicated to the state have to
yes,
issue.
you can- because he's a most probably under this, he's a police person.
Yes,
He is police person. On the basis of the,
informant.
yes, telephonic information, this case was registered. Thereby this name
Now
of,
we have received the case diary also. I think.
Yes, your lordship. Case diary is with me, your lordship.
Yes.
Now, this court has to determine whether the Arms Act, the section of the Arms Act can be washed under 482 or not. That has to be determined by this honorable court.
Only that is the issue. I think.
Yes, and last occasion, they have referred to judgment, that is Surendra Singh versus State Union Territory, and the order passed by the coordinate bench, Sri Taing Anthony and another versus State of AP, your lordship.
The Surinder Singh.
Yes, your lordship. That was after conviction, your lordship. In my humble-
Anyway, Surinder Singh was by the petitioner side.
my lord.
You relied on this petition, na? Surinder Singh was relied by you only.
Narendra Singh as well as in the,
Surinder Singh, who relied on Surinder Singh?
They relied, your lordship. It's-
Surinder Singh versus State of Union Territory Chandigarh,
my lord,
you relied.
yes. At the same
And
time,
one
my lord,
Lakshmi Narayan is also here, Lakshmi
I-
Narayan. is-
Lakshmina, I relied, your lordship.
I also relate to my lord, the one criminal petition 109 FP.
Yes, by the coordinate bench.
Coordinate.
Trying it.
Yes, okay.
So in the, my lord, in the argument point of view, I would like to highlight this Narendra. What has been covered in the Narendra Singh, my lord.
Yes, you can.
My lord, may kindly come to the page number 483 of the Narendra Singh, para number 29.2.
Who's para number?
Para number Narendra Singh. ma'am.
You are on Narendra Singh.
Yes.
But we have submitted here Surinder Singh.
Equally.
Yeah, Narendra is there.
They have not submitted, your lordship.
Today you are going to rely on Narendra Singh.
My lord.
We don't have any copy. You have just supplied on that day, most probably Surinder Singh is.
Yes. my
And
lord.
one
I should
judgment
have.
of the coordinate bench.
So far, my lord, the Narendra Singh and the Lakshmi Narayan is my lord concern. Both the cases cover that if the my lord matter, if the honorable court find it, whether the possibility of convicting the accused in the case is bleak or remote, if affirmative, that can be quashed. Despite even my lord, other than the section involved in my lord 207 also, 27 of the Armed Acts also. So my lord, in the same my lord, in reporting to the same statement, the decision was taken by this honorable court or in tying Anthony and others versus State of AP, wherein my lord, I would like to read out the operating person, my lord. My lord, may kindly take to the judgment of tying Anthony and others.
Criminal petition 109.
Yes. And my lord, may kindly come to page number 2, because despite of going through, my lord, everything, my lord, I will go confine with the relevant portion of it. Para 2 of My lord, page 2, this will be the, my lord, second last, my lord, paragraph, my lord, got it? In this instance, can the petitioner or the complainant and accused are being close relative and also stated to have resolved their differences and misunderstanding by the agreement number such and such. It is found that the complaint number 2 is unlikely to give the evidence in the connection with the offense alleged against the accused number 1, as a result of which the possibility of accused being convicted in the proceeding pending before the learned court below appear to be bleak and remote, and in view of the matter, it is deemed appropriate to quash the criminal proceeding against the petitioner number 1 pending before the court of the learned chief judicial magistrate in year number such and such. So, my lord, here the contention is that despite of this is also case wherein, my lord, the register was made under section 27 of the Arm Acts. Despite of the 27 of the Arm Acts also, my lord, it has nothing found. And so far, my lord, 27 is concerned, my lord, the reading of the 27 of the section 27 of the Arm Act itself, my lord, does not reveal anything what has been or what done in the incident. Section 27 is, my lord, punishment for the whoever used any arm in the immunization in contravention of the section 5 shall be punishable in the imprisonment. My lord, person who have committed in contravention of the section 5, my lord, shall be punished. What the section 5 said, my lord, section 5 is the manufacture and the production. So, my lord, despite that the section 27 is given, but this is clearly, my lord, there is prima facie that involvement of the section 27 in the Armed Act is not at all, my lord, not at possible at all, even if the trial is allowed. Therefore, my lord, my prayer before the lordship that this is the paid case to be, my lord, allowed, granted, and quash the criminal proceeding against the petitioner. Since both the petitioners are the accused and the victim, when they have already resolved their differences. In fact, my lord, that was so. Even if my lord observed the incident, what had happened, in fact, there was nothing. Both were a friend. They have went together in their one festival, and out of drunk, there was little bit argument between them, and out of that argument, one take out the revolver and fire in the air, and that information was informed to the police. So later on, when they realized that should not have been, so my lord, they rushed to the police station. But since the matter is non-compoundable, so despite of their effort,
the vehicle, the arms was used.
that
Even if suppose in open fire or blank fire or open fire, in that case also the arm was used.
my lord, that arm was used by the, my lord, petitioner number 2, that unintentionally and without any motive, my lord, that was out of the drunk, and since both the friends were, my lord, attended a festival, my lord, on that occasion. So, my lord, it is affirmative that there will be that the petitioner number 1 as a victim shall not go to the court for, my lord, giving the evidence. So in such situation, even if the proceeding trial is allowed, my lord, that will be the nothing but the futile exercise of the court. Therefore, my lord, this may be granted.
May I, Lordship? Your Lordship, I will come chronologically, Your Lordship, of the incident, Your Lordship. Firstly, I will read the FIR, Your Lordship. Because since, Your Lordship, the Arms Act involved, that's the reason, Your Lordship, being a prosecution, I have to object it, because the Lakshmi Narayan case, there is a clear parameter. After the Narendra Singh also, Lakshmi Narayan case is there, and I will distinguish the judgment whichever my learned brother has referred to. In your lordship, page number 15, annexure A, the FIR, your lordship. May I read, your lordship? With due respect, the undersigned would like to inform you that to early morning at 4:30 hours, information received from Control Officer Itanagar that control has received from a person introducing himself as Takpu Raimo, the present petitioner, that he was arguing and quarreling with one Jerot Mara, an official resident of Sri Punji Mara at ESS sector Itanagar. Upon receiving the information, the undersigned being IC PCR2 along with Constable K. Jilen and Bogom Kachak rushed to the spot. On reaching at the spot, it was learned that while tussling Jerot Mara, aged 37 years, so and so, village so and so, POPS so and so, District Upper Subansiri AP, and presently residing at ESS sector Itanagar, took out his licensed pistol and fired on air. Accordingly, rescued the informant and taken accused to police station Itanagar, where handed over accused and pistol for necessary legal action, your lordship. Now, from the FIR, your lordship, the prima facie case is made out, and to that effect, your lordship, as your lordship, it's everything there in the case diary. The firearm, the arm has been recovered from the accused, your lordship, from his possession. Now, your lordship, at this stage, I will, your lordship, reiterate the Aryan Singh case, your lordship is well aware of the case. That while considering the 482 application, your lordship, whether it is settlement or not, the Supreme Court has not distinguished it, whether it is considering the 482 application. Law doesn't permit the court to conduct mini trial, your lordship. Mini trial in the sense whether the section is abstract or not, because, your lordship, under section 114 of the Evidence Act, the presumption that the official has performing his duty, it will be always presumed by the court if there is a material as such. And so far as material is concerned, is there, and your lordship may see section 30 of the Arms Act. Section 30 of the
Professional license, actually.
Yes, your lord, section 30, your lordship. It doesn't speak about the license, but the license condition, when license condition has been violated, your lordship. So, your lordship, when the license has been issued, the certain terms and conditions are imposed to the arm holder or the license holder that you cannot do this and that. And if that thing is violated, then he is liable for the punishment under section 30 of the Arms Act. And now, your lordship, now come to Lakshmi Narayan case, your lordship. Lakshmi Narayan case clearly says, so far as IPC is concerned, if there is an incorporation of section 307, then court has to see whether it has been incorporated only for the namesake. And that can be done only after completion of the investigation. But in Lakshmi Narayan, it clearly specifically mentioned the Arms Act, your lordship, meaning thereby all the sections in the Arms Act are serious offense and it's against the society. And your lordship, every time we use the word ends of justice is not only confined to an individual. Ends of justice means what, your lordship? It's a preservation of proper balance between the constitutional or statutory right of an individual and the public at large to law have been enforced, your lordship. So now, why it is against the society, your lordship, the Arms Act? It is specifically, your lordship, considered by the Honorable Supreme Court. And your lordship, the judgment, whatever my brother has relied, your lordship, parts of the coordinate bench, your lordship, from our High Court itself, in the judgment, your lordship, only Narendra Singh case was relied upon. The Lakshmi Narayan case was not taken into consideration. Your lordship, I have gone through the judgment. Only Narendra Singh has been referred, your lordship. And so far as the second, your lordship, the judgment, the Surendra Singh case is concerned, your lordship, that come only after the conviction. It doesn't speak about the, your lordship, settlement, your lordship. If prima facie case is made out and the prosecution collect a sufficient material, your lordship, and the offenses which is against the society, they have to come across the trial. And if there is nothing against them, then they will come out unscratched, your lordship. The purpose of 482 on the basis of settlement is not to quash all the matter, your lordship. Only if it is in private dispute, even, your lordship, the rape, rape is a very serious allegation, your lordship. But considering fact and circumstances, your lordship, the court interfered because there are some false allegations are there, even false promise of marriage allegations are there, your lordship. For that fact has to be looked into, your lordship, not only the incorporation of the section. So, your lordship, so far as the Arms Act is concerned, since my learned brother has relied on the coordinate bench judgment, I would like to rely the coordinate bench judgment on the same aspect again, your lordship. The judgment which my learned brother has referred, it was passed in 2018. And now I'm relying on your lordship GLT 2022 volume 3, 382, your lordship. The coordinate bench, para 9, 10, and 11, your lordship. May I read, your lordship? May I read, your lordship? So what come through loud and clear from the point number 4 of para number 13, above that the offense under the Arms Act, that is relying on the Lakshmi Narayan, under the Arms Act, would fall in the category of heinous and serious offenses, and therefore are to be treated as crime against the society and not against the individual alone. And therefore, the criminal proceeding for the offense under the Arms Act have a serious impact upon the society, and therefore cannot be quashed in exercise of power under section 482 of the court, on the ground that the parties have resolved their entire dispute among themselves. It is to be mentioned here that the petitioner number 2 here in this case is charge sheeted. Here matter was charge sheeted under section 337 IPC, read with section 25 IB 27I of Arms Act. Since the Honorable Supreme Court in the case of Lakshmi Narayan Supra, in no uncertain terms state that the offense under the Arms Act fall in the category of heinous and serious offense, and since the petitioner number 2 is charge sheeted under section 25 IB 27I of the Arms Act, which are to be treated as crimes against the society and not against the individual alone, the instant criminal proceeding for the offense under Arms Act cannot be quashed in exercise of power under section 482 of the court, on the ground that the party have resolved their entire dispute among themselves. I have considered the submission of the learned advocates for both sides, and also consider the fact and circumstances of their own record, and I find that the submission so advanced by the learned counsel for the petitioner devoid of merit, the ratio laid down in the case of Lakshmi Narayan, so referred by him and discussed herein above to consider opinion of this court, would not come into his aid. Here, your lordship, it clearly says it's not about the section, it's about the act itself, your lordship. And the act will against the society, the offense will against the society, it will not be considered as an individual, even if they enter into an agreement, your lordship. And I will rely on the, your lordship, judgment of the coordinate bench, order of the coordinate bench, when Arms Act was quashed, but fact, basing on the fact and circumstances, your lordship. No doubt the Arms Act was quashed, but your lordship may find the observation there in your lordship. I will only read para 9, your lordship. Here, initially FIR was registered under your lordship, Arms Act, your lordship, and investigation has been carried out. Para 9, your lordship. The Honorable Supreme Court has held that a mere allegation of attempt to commit murder would not lie if there are no material under the section of law. Here also there is an allegation under section 25-27 of the Arms Act, but no weapon or arm could be seized by the police. So at this juncture, I have sufficient reason to hold that there is no possibility of future conviction of the accused person under 25-27 of the Arms Act. Considering the fact and circumstances, your lordship, the arms were not recovered, so it will not affect, your lordship. Basing on that only, it was quashed. And in the present case, your lordship, seizure memo is there. It clearly seized from the person, and no doubt they have produced the, your lordship, their license also. But section 30 will always be there. And all this disputed aspect has to be placed before the learned court below while considering the charge, your lordship, under 239, 227, or 245, as case may be, your lordship. Not at this stage, because investigation is not complete yet. Tomorrow, your lordship, he may not be charge sheeted under 25 or 27. But at this stage, when they is squarely approaching the court on the basis of settlement, they cannot disputing the, your lordship, fact that this will attract, this won't be attract, your lordship. And this is also from the coordinate bench judgment, your lordship, order, your lordship. So in page number 5, your lordship. I am not saying that Arms Act section cannot be washed, but considering the fact and circumstances, because the court has to look into whether it was incorporated from the namesake or not, that has to be looked into. Second last paragraph from today, your lordship, today. Yes. Today I have gone through the case diary, and it revealed that the gun in question was not in the possession of the petitioner on the day of occurrence. Therefore, there is no prima facie case made against the accused under section 27 of the Arms Act to go for a full trial. the other offense in this case can be compounded. So in the case in hand, there is no possibility of future conviction of the petitioner. I am of the considered opinion that the allowing the proceeding before the court below to continue would be an abuse of process of the court. Therefore, prayer of the petitioner is allowed. Here also 27 was quashed, but considering the fact and circumstances. Now, your lordship, I will, your lordship, produce the case diary, your lordship. Whether, your lordship, all this, both the section will cover his case or not, your lordship. Your lordship may see in the paragraph, your lordship, page number 3. Page number 3, your lordship. Whether it has been pagination has been done or not.
Yes,
Three.
page number 3.
3, your lordship.
Yes, 3.
Yes, your lordship.
It's a affair.
Not FIR, your lordship. That is the case diary, your lordship.
It's
There may be a variation, your lordship, in the case diary, your lordship. Your lordship may kindly peruse it, your lordship. Since it's a case diary, I cannot read everything, your lordship. Second para, your lordship.
Case diary. It's a
Yes.
FCR or case diary. Scan copy of LCR. You have received the scan copy of the LCR. Case diary is there, not this is. So we are not with you the case diary. Okay, then you give me the copy.
LCR
We will not.
is. Scan copy of LCR perhaps there, your lordship.
It's
It's reflecting.
Yes.
Caesar is there, your lordship, in second. She's from the present
Yes.
petitioner number 2, your lordship. So, your lordship, here even both the judgment which I relied, that will not be attracted, your lordship. Now, prima facie case is made out. Section 30 clearly attracted. 25 and 27, I will not argue because this is not the right stage to argue because it's a 482 application since the court cannot hold a mini trial at this stage. So now, considering the, your lordship, parameter laid down in the Lakshmi Narayan case, your lordship,
So what is the status of the investigation at present?
your lordship, as per the
For the heavy report. I mean,
as per the case diary, your lordship, status report, only for the want of sanction, the matter has not been charged sheeted. Other part, everything is over. Statement, everything has been recorded, your lordship. Now, your lordship, I will conclude my argument by relying on the para of Lakshmi Narayan case, your lordship. Reported in 2019 5 SCC 688, para 15, your lordship. Otherwise, your lordship, the same was reiterated in the reported judgment of the coordinate bench only, your lordship. Just for my satisfaction, your lordship, I will read out. There are 15. Considering the law on point and the other decision of this court on the point referred to herein above, it is observed and held as under 15.4, your lordship. Offense under 307 IPC and the Arms Act, etc., would fall in category of heinous and serious offense, and there are to be treated as crime against the society and not against the individual alone. And therefore, the criminal proceeding for the offense under 307 and or the Arms Act, etc., which have a social serious impact on the society, cannot be quashed in exercise of the power under Section 482 of the Code, on the ground that the parties has resolved their entire dispute among themselves. However, the High Court would not rest the decision merely because there is a mention of Section 307 in the FIR or the charge in the charge frame under under this provision. It would be open to the High Court to examine as to whether incorporation of Section 307 is there for sake of it, or the prosecution has collected sufficient evidence which, if proved, would lead to framing of charge under 307. For this purpose, it would be open to the High Court to go by nature of injury sustained, whether such injury is inflicted to vital delicate part of the body, nature of weapon used, etc. However, such an exercise by the High Court would be permissible only after evidence is collected after investigation and the charge sheet is filed, charge is framed, and during the trial. Such exercise is not permissible when the matter is still under investigation. Therefore, the ultimate conclusion in para 29.6 and 29.7 of the decision of this court in Narendra Singh should be read harmoniously and to be read as a whole and in circumstances stated herein above. First part, your lordship, we speak about 307 and Arms Act. Arms Act, regarding the Arms Act, no explanation has been given. Supreme Court simply said if Arms Act is there, the court should refrain itself from exercise 482. But when 307 and other offense come, then court can scrutiny consider the matter by after completion of the investigation whether sufficient material has been collected. So in my humble prayer before your lordship is this prima facie case is made out, sufficient material is collected. at this stage, the remote and bleak chance of conviction cannot be, your lordship, considered. The sufficient sufficient material has been collected and the offense is against the society, and the Lakshmi Narayan case, under Lakshmi Narayan case, this case will not fall, your lordship, of license.
My lord, I'd like to reply 1 or 2 lines. In fact, my lord, so far the reading is concerned. Finally, my lord, my brother has pointed out the Lakshmi Narayan 207, my lord. Therefore, the ultimate conclusion in the para 29.6 and 29.7 of the decision of this court in Narendra should be read harmoniously and to be read as a whole in the circumstances stated above. Meaning very clearly stated that, my lord, the para number 29.6 and 29.7 of the Narendra should be, my lord, harmoniously, my lord, they should be taken together. Despite, my lord, the discussion has been made pertaining to the arms act. And so far, my lord, the argument is concerned, my lord, I have not found any contradiction from my brother, because the PP, from the PP, brother is also saying that there cannot say that the arm act cannot be quashed. One arm act can be quashed on the facts, basing on the facts and circumstances. Exactly, that is my argument, that I have never said that there is section 30 of the arm act. I admitted that was done. But why I am seeking for the quashing on the facts and the circumstances, what had happened in that night. So therefore, unintentionally, and that was not harm to any public, and that was not in danger to the public. And my lord, lastly, so far the 307 of the 30 of the arm act is concerned, its punishment goes up to, my lord, up to six months. So in such a circumstances, my lord, both the case Narendra Singh as well as this is covered, that this under 482, the my lord has, my lord, the discretion to decide that maybe, my lord, was.
Ah, 22. Oh. Actually, we have not received the LCM, or we have already received? Not yet received. Not reflected in a call, this means we are not received actually. So appeal is for hearing, and along with one I is also there. So you are ready for suspension of that matter? Have you filed any objection?
Your lordship, actually in same situated case, your lordship has suspend the sentence, your lordship.
I don't know what is this similar situation.
Yes, here, your lordship,
Now, if you're ready for placing the objection or whatever, then you can ready to hear it. Now, because I'm asking you why, because LCR is not there.
yes, your
So
lordship.
without any answer, if you have other materials to file any objection verbally or whatever, then we are ready to hear. Otherwise, I can be disposed of in that case.
Your lordship, then let them argue, your lordship. On the basis of their argument, I will raise an objection, your lordship.
So we are on I now. Conviction was under which section?
Lordship, conviction was under section 21 small a, 27 small a, 27 capital A, read with 29 of NDPS Act. He has been sentenced to 1 year with fine of 10,000 under section 21A and 27A, and rigorous imprisonment for 10 years with fine of 1 lakh.
27A
27 capital
capital.
with a fine of rupees 1 lakhs only. Lordship. Lordship,
Now, since when they are in custody?
since they are in custody since the date of the judgment, Lordship, 15/6/2020.
15/6.
Yes, Lordship.
During the entire period of trial, whether they were in.
They
bail?
were under bail. They were
Under bail.
bail. Lordship, if I may, I would like to read the FIR, Lordship.
Hmm.
Page number 66 of our appeal, Lordship. To the officer in charge, police station, Bomdila, was coming.
Page,
Page number 66, Lordship.
of
Of our,
appeal.
yes, Lordship. We have annexed the reports in the appeal, Lordship.
Yes.
Sir, with due respect and most humble, I would like to inform you that on 26 June 2020, at 1400 hours, on receipt of information from a reliable source, SPS Bomdila, that one suspected to be drug peddler, namely Shri James Tinjing Rijidu. This person is me. Is trafficking a huge cashman of narcotic drugs from Assam to Bomdila through Balekpung with help of one Shri Tasi Bhai. This is the accordingly, self with OCPS Bomdila and a team of Bomdila PS staff left PS and intercepted on Shri Tashi on highway, who was found coming on a scooty bearing registration number AR05 3808, and on being searched, 7 vials of narcotic drugs, heroin, recovered from his possession. On being examined, Shri Tashi revealed that Shri James sent him with the recovered drugs to sell it in Bomdila to the addicted persons on rupees 5,000 only per vials. Further, he disclosed that Shri James had financed the other party in Assam to procure the said drugs. Accordingly, on being led and shown by Shri Tasi, suspect Shri James apprehended from Balekpur and a vial containing suspected to be narcotic drugs, heroin, recovered from his possession. Further, Shri James revealed that on 26 June 2020, he had sold 5 vials of suspected to be narcotic drugs, heroin, to Shri Tashi Babu, and led us to show the place where they were consuming such contraband drugs. Accordingly, Shri Tashi Babu with one Deep Jyoti Patra were apprehended red-handed while consuming such drugs at the house of father-in-law of Shri Tenjing Ki, late Shonso, in Upper Balekpung. Hence, all of them has been apprehended and brought at PS Balekpung and then at Bomdila PS for further course of action. Now, based
Out of the other accused persons, you are being convicted with 27 capital A.
yes, one
Rest
me,
of the person,
me and one of this Tashi Babu. He was also convicted of 27. Now, based on this FIR, after investigation, Lordship, charge sheet number 46 of 2020 was placed before the learned special judge Bombay. Accordingly, after the trial, Lordship, by judgment dated 15/6/2023, the I was convicted accordingly 1 year and for 10 years. And Shri Tashi Babu, Lordship, he was also similarly convicted. Now, Lordship, during the trial, from Lordship, from the perusal of the FIR and from the perusal of FIR, and Lordship, we have annexed the statement of 3 witnesses. We are basically relying on the depositions of 3 witnesses, the informant himself, the IO of the case, and an independent and chance witness who was there, who was with Shri Tashi Jairam when this seizure of the drugs was made. Lordship, we have annexed their
the persons who are being examined, other accused, other witnesses,
yes, Lordship.
or already been examined, you have not produced, or why you have not produced it? Because now see,
Oh, yes.
21A, small a, or 29 may be there, but
Yes.
we are concerned about 27 capital A.
Yes, Lordship.
And the FI ingredients of the plain reading of the FI speaks that he was financing or he was helping whatever to the other accused person for bringing those to his hand. So
Yes, sir.
ultimately, prima facie, there is a 27A, prima facie. But you have produced the examination of 20, only 3 witnesses.
Yes.
The rest
The-
of the witnesses, why you have not annexed the other evidence of the other witnesses?
Actually, Your Lordship, the prosecution has relied on 9 witnesses. First is the complainant, of whose we have. Second is Sri Talung Yang. We have also, he's a Caesar witness, we have also. Now, Srimati Jumir Kato, she is my wife. She is also Caesar witness regarding the Caesar marriage matter. Then Sri Tenjin Ki, he is a Caesar witness of Sri Tashi Papu, not connected witness. Then Sri Kesang Wangde, he is the executive minister, or executive magistrate. And then Srimati Inba Devi, she is an SSL expert. And then there is Inspector K. Dev, the OC, the IO of the case. So, Lordship, this K. Kaba, who is the informant also, he was also one of the eyewitnesses. He accompanied the IO of the case to the place where it was seen. So we have annexed. If I may be allowed, Lordship, I would just like to highlight the relevant portion. Lordship, I would like to read out it is at page number 67, Lordship, of K. Karba, PW, the cross examination, Lordship, what he stated. It is fact that the FIR was drafted by OC and I put my signature after read the contents of FIR. It is not fact that I did not know the contents of FIR. We did not inform the magistrate about the apprehension of Sri Tashi Jera and also to the other. I have no idea about explanation of rights to the accused before search. I did not hear the disclosure statement of accused Tashi Jera. And the second clause, Lordship. I cannot say the exact location of the highway where accused Tashi Jera was apprehended. Court examination, one question also. I did not know the source of information. The source of information was known to the OC, Mr. K. Now, Lordship, that is there. Now, Lordship, this is the sole independent witness, Sri Taluk Yang. Apparently, Lordship, this Tashi Jera has taken a lift from him and they were apprehended. Now, Lordship, the relevant portion, it is at page number 69, the entire deposition. The relevant portion being, Lordship. It is a fact that the police searched our body as well as luggage. It is a fact that there was no magistrate except police at the time of search. It is a fact that we were not asked by the police personnel as to whether search was to be made before the magistrate or not. It is a fact that I have no knowledge whether the recovered vial contained drugs or not. This is a fact that I did not know the weight of the thief article mentioned in the exhibit report. Now, look,
We were not asked by policemen, he is a witness too.
he is a
EW4.
Yes.
EW4 is also a witness.
Yes, Lordship. He is an independent witness. He was riding the scooty which was apprehended by the police. He was riding the scooty wherein Tashi Jera
He was also being searched, I think.
He was also searched and the other accused person was also searched. Both of them were searched. Now, Lordship, then comes the statement of the eye. During his deposition, Lordship, it's a 5-page long deposition, Lordship. But if my Lord will come to page number 75. 75. Now, herein there is a cross examination, his cross examination. He has very categorically stated, if I may read. Well, I have not conducted body search of Tashi Jera. I have recovered the contraband substance from black polythene carried on his hand. I have not conducted body search of accused Tashi Jera, but I have searched the scooty. It is not a fact that I have not informed my superior about seizure after search and seizure. In this,
Does his cross evidence, it very much evident that there was no body search. Because there was no body search. The scooter was being searched and other things were searched. So compliance of section 50 and the case will not be affected.
Your Lordship, our submission here, there are two things that the IO has misled the court about. One thing is section 42, Lordship, regarding the notice. As apparent from the FIR, Lordship, the FIR says the Lordship that he has prior information regarding that some person was carrying drugs from Assam. Now, during the whole trial, he did not produce the consent communication that he is bound to make to his superior. He has not produced. In fact, he has
superior communication to superior will come whether he is authorized person to conduct a search under 42. That has to be.
Lordship, he is deemed to be a authorized person. And accordingly, he has it. And most of Lordship, this being 42, the first 42. Now section 50, Lordship. Why we are relying on the statement of this PW4 is, Lordship, these are police persons. The first complainant is a police person himself who is functioning under the OC. And the OC is himself, he has seized, and he is also the OC of the same case also. He has seized and he has investigated also. Now the only person who was nowhere connected in this matter was this PW4, Lordship, Taluk. And Lordship, in his cross, it is a fact that the police search our body as well as luggage, Lordship. Now, Lordship, even if it is to be considered, Lordship, firstly, a person comes in a scooty and it is alleged that he is carrying drugs. Lordship, it is an impossibility that the police will only search the scooty and the police won't search the body of a person. That even if something is found in scooty, there will be something that will be there in the body as well. That is something to be considered. Now, Lordship, why we are stressing upon this is because, Lordship, if the section 42 compliance and section 50 compliance is not taken into account, then the whole prosecution case goes. And even, Lordship, if there is a observation, Lordship, by the Honorable Learned Special Court, Lordship, wherein the disclosure statement made by Shri Tashi Jain is taken into account. Now the disclosure statement, he says that I have 7 vials which were given to me by Shri so-and-so, by me, for sale. Now, Lordship, as my Lordship knows that for a disclosure statement, it is something that is given after an arrest. They had already apprehended me, they had already arrested me, and then they had written something that these vials were given to me. That is not a disclosure, Lordship. They already knew, there should be a discovery of fact, Lordship. There is no discovery of fact. Now, Lordship, even when they came and they arrested me, they have seized something, apparently. But that thing that was seized was not sent to FSL, Lordship.
Not?
Sent for FSL, Lordship. There
There's
have
no FSL report.
against me, Lordship. There is nothing.
FSL report was there, one because FSL expert.
For the other accused person, for the 7 vials, that were apparently recovered during the Bomdila search on the way. From me, 1 vial was recovered, but if it on record, Lordship, that it was not sent for FSL.
Where it is taken.
Lordship, yes. Lordship, this page number 74, Lordship. The cross-examination of the IO, the last line, if you may, Lordship. I have not sent the vials recorded from Tashi Baku and Shri Tenjing Tharodot Rijuju for FSL examination, as contraband substances were too small for FSL examination. Now, Lordship, it is there an excuse that the amount was so that it could not be sent for FSL. Now, on record, Lordship, firstly, Lordship, there is in non-compliance of section 42 and 50, Lordship. Then again, if the whole prosecution case goes, then also if they come to me, now what they have done is they have said that I have been seized with some items. Now, Lordship, NDPS, the punishment is so rigorous, Lordship. They have convicted me without me being in possession of anything. Not even how they came to my house, that is also in dispute, Lord. But they have come to my house, they have said that, okay, I have found you with something. But now that something is also not been sent for FSL. Now, without an FSL examination, Lordship, how it will be determined that what it was exactly that I was in possession of, Lordship. Now, Lordship, the police can very well plan anything. The procedural safeguards are there for this reason, is Lordship. If I may, Lordship, I would rely on 2 judgments.
You rely on judgment first to finish your argument. What are the sections which you supposed to say that these are the, there is a total non-compliance of those sections, which are the mandatory sections.
Yes, Lordship,
Is there any? Because 50, I think, will not come. 42 will also,
Now, Lordship, the 42 Lordship, even if it is considered, maybe he could have done, Lordship, but the
hmm,
PW4 Lordship, the only sole independent witness Lordship, by whose testimony we are, a court can, Lordship, the police, once they have said that I have been put in position, they will do what in their power to prosecute me, Lordship. Now, Lordship, the procedural safeguards, Lordship. For this very reason, Lordship, they have to prove the case against me, Lordship. Lordship, they very well could not even prove, Lordship, that because, Lordship, it is not because there is direct contradiction between what the IO has said and what the only sole independent witness has said.
your petitioner's name is, your appellant's name is Tanjin.
My Tenzing Terror, TT Rijiju, Lordship. This other person was caught, and apparently he has brought me based on a disclosure statement, which I would humbly submit that would not count, Lordship, as if it is not a disclosure statement. Now, Lordship, if the possession and everything else is to be taken out of consideration, Lordship, now comes 27, Lordship. Now, Lordship, if the provisions of section 50 and 42, because, Lordship, this mandatory provision wishes the whole trial. If these provisions are due to the non-compliance of these provisions, the prosecution is vitiated. Lordship, nothing proceeds further from that point at Bombay. They cannot come back to me at Baleppung and they cannot seize anything from me. And Lordship, they have in fact, they have only said that something has been seized, but they have not proved what has been seized. Now, only the thing is they are saying that I have financed or I have harbored. Now, Lordship, there is nothing in there. Financing, Lordship. How they will prove that I have financed, Lordship? A person, Kashi Jerang, was arrested near Bombay, Lordship. He had no money with him. He has no money, he has nothing that connected that person to me. The only thing that is connecting is a supposedly purported disclosure statement given under 27 of Indian Evidence Act. And this a procedure, a seizure, which has been done in total non-compliance of section 50 and 42. That is the only thing. Now, supposing there was some transaction which would have connected me to this Kashi Jerang, then it could have made sense that I could have been charged under 27. Now that is not there. Now they have been unable to establish a connection between me and this Kashi Jerang. Now, if there is no connection, Lordship, if there is no connection, there is no question of 27A. Now, for even the application
For the disclosure statement of Kashi Jerang or what is this? Kashi Jerang. What is his disclosure statement? It reveals something.
Lordship,
They have not annexed this. The disclosure statement is not annexed here.
Pardon, Lordship.
Disclosure statement is not annexed here.
Disclosure statement. Lordship, we have even the content of the disclosure. It is in page number 47. Lordship. 47. This is it was reflected in the judgment. Lordship.
In para number,
The fourth, fifth line, Lordship.
para number.
The first para, Lordship. Fifth line. Said fact is also proof from the exhibit number 2. Exhibit number 2 is the disclosure statement, Lordship, wherein accused Kashi Jerang disclosed that Tenzing Terror Rijiju, the appellant here, Lordship, the convict, Lordship, has given 7 vials of contraband substance to him to sell at Bomdila and gave his bank account number to deposit the money. Now, Lordship, that is based on a disclosure. It is said that it is based on a disclosure statement they found out. Now, Lordship, the FIR itself, it is very evident that those 7 things were already they were already apprehended by the police by the time I was arrested. Now, there cannot come a question of disclosure, Lordship. No new fact has been revealed. If they have treated the disclosure statement as as a confessional statement. And my lord also knows that a disclosure statement can only operate against the maker. Now, if he says that he has taken the 7 vial, the court may very well take it into account. But that statement that has been made on 27 Lordship of Indian evidence cannot be used against any other person. So if that statement cannot be used against me, Lordship, the police had no right to come to my home. And even after coming to my home, Lordship, as I've already repeated, Lordship, they found nothing. So now, Lordship, the reason for this appeal is that, Lordship, the concerned section, Lordship, the procedural safeguards, Lordship, why they are given such a rigid reason, Lordship, is for this kind of situation only, Lordship. Now, Lordship, even if everything is to be considered, Lordship, that I have a good ground to go to appeal, Lordship. I have not misused my liberty when I was out during trial, Lordship, and I am also out here seeking justice, Lordship. Even if two views are possible, and my humble submission, Lordship, based on at this junction, Lordship, based on the statements, the PW, the depositions, and how the police have proceeded to prosecute me and arrest me, Lordship, there is a chance also, there is a reasonable chance that my appeal will succeed, Lordship. My only prayer being that I may be allowed to defend myself. I may be allowed to be at liberty, Lordship, during this period, Lordship. I have not misused anything. I will not misuse anything. This honorable court may, Lordship, impose such terms and conditions, Lordship. Lordship, in this regard, to conclude my submission, I would like to place 2 cases.
Well, it's not the same, I think, no?
Lordship, apologies,
Okay,
Lordship, the wrong side. So we only rely on that.
This of that one.
This is not related. This is not.
Jag-
Jagjat Singh.
Jagraj Singh. It is not,
That
it
is
is not.
that is not. Now, Lordship, from this Dilip and others versus state of MP, Lordship, there's a small para from para 5. Page 6, para
Dilip.
page 5, Dilip, Lordship.
Achha.
Page 5. This is a para 5, Lordship. This is, Lordship, regarding 41.2 and 42, Lordship. If I may read, Lordship. On prior information, the empowered officer or authorized officer, when acting under section 41, subclause 2 and 42, should comply with the provisions of section 50 before the search of the person is made, and such person should be informed that if he so requires, he shall be produced before a gazetted officer or a magistrate as provided therein. It is obligatory on the part of such officer to inform the person to be searched. Failure to inform the person to be searched, and if such person so requires, failure to take him to the gazetted officer or the magistrate would amount to non-compliance of section 50, which is mandatory. And thus it would affect the prosecution case and vitiate the trial. After being so informed, whether such person opted for such a course or would not be a question of that. Now, from the position, Lordship, it is revealed that the OC says that I have never body searched him only. But the only independent PWS, he has very categorically stated that our body search was done. And our luggage and as well as our body search was done. And we were not informed regarding any search to be done before the magistrate. Now, Lordship, the other one being Sukhdev Singh versus State of Haryana, page number 6, Lordship. Para 22 and 23.
Para?
22 and 23, page number 6, Lordship. I will read, Lordship, para 22. There is patent illegality in the case of the prosecution. As such, illegality is incurable. This is a case of total non-compliance. Thus, the question of substantial compliance would not arise for consideration of the court in the present case. The twin purpose of provision section 42, which can be broadly stated, are that it is mandatory provision which ought to be construed and complied strictly, and compliance of furnishing information to the superior officer should be forthwith and within a very short time thereafter and preferably post-recovery. Now, in his deposition, he has very categorically stated that I have not produced anything before the court. Nothing is exhibited at the court. Once the contraband is recovered, then there are provisions like section 57, which the empowered officer is mandatorily required to comply with. That itself to some extent would minimize the purpose and effectiveness of section 42 of the NDPS Act. It is to provide fairness in the process of recovery and investigation, which is one of the basic features of our criminal jurisprudence. It is a kind of prevention of false implication of innocent persons. The legislature in its wisdom had made the provisions of section 42 of NDPS Act mandatory and not optional as stated by this court in the case of Karnal Singh. Now, Lordship, based on these two citations, Lordship, I am saying that in the face of total non-compliance of 42 and section 50, Lordship, the prosecution case goes, Lordship. And if the prosecution case goes, nothing survives against me, especially when I have not been subjected to FSL examination, my CA. And Lordship, lastly, this Honorable Court, Lordship, on 1st of August, had given this paid, suspended the execution of this Tashi Babu. He is also convicted under 27A. So, Lordship, it is kindly prayed that we are similarly placed, Lordship, our case. So, Periki may be kindly considered as well, Lordship, in our case.
Tashi Babu's appeal is other appeal.
It is connected appeal, Lordship. It was
Why these are not been?
44 of actually,
Yes, Lordship, that is the difficulty. Actually, both the appeals should have been taken up together, Your Lordship. This,
So there is, we have a certain our prayer is the Lordship that we may be already so we consider for situation of our sentence.
Yes.
yes, Lordship, actually I'm indicating this order because Your Lordship has given the observation on 40 and 50 itself, Your Lordship. So, Your Lordship, so far as if section 50 and 42 is not complied with, Your Lordship, then the prosecution case goes, no doubt, Your Lordship. But so far as, Your Lordship, section 27A is concerned, and it has to be read along with the section 50 and 42 also, because in 27A, Your Lordship, it is not condition precedent that the contraband substance should be recovered from that person. It speak about the trafficking, Your Lordship. Who has a constructive, it may not be in his absolute conscious possession, but it may have the constructive possession. Who can control the, Your Lordship, transportation or business of the particular substance, Your Lordship. That is the ingredient of section 27A. However, Your Lordship, because Your Lordship, there is a finding from the early, one of the appeal, Your Lordship, since observation has been given on 42 and 50, Your Lordship. If 42 and 50, if this court find that there are some non-compliance of the both mandatory provisions, Your Lordship, then, Your Lordship, it will be difficult for the prosecution to establish 27A also. And so far as, Your Lordship, FSL is not, if suppose in absence of FSL, that means there is no any contraband. If contraband is not there, then automatically, Your Lordship, the other section 27A is directly connected with the contraband substance, the transportation, directly or indirectly. Whether that person is the main financer or not, that is immaterial. In between the peddler also, Your Lordship, indirectly this is involved, transporting from this person to this person. But the condition precedent for the NDPS case is the, Your Lordship, ultimately the FSL report, Your Lordship. Whether the contraband substance is there or not recovered by them, it is suspected one. If, and so far as the present appellant is concerned, Your Lordship, the non-recovery of this contraband substance from his possession to attract the 27 is immaterial. But to substantiate 27A foundation, Your Lordship, the other mandatory provision, that is 42 and 50 of the NDPS Act, that has to be complied with. Otherwise, Your Lordship, there is a possibility of succeeding the appeal, Your Lordship. So far as, Your Lordship, suspension of this sentence is concerned, Your Lordship, recently the Supreme Court, Your Lordship, I will just rely this principle, Your Lordship. Para 33, Your Lordship. The court is not required to see the loopholes and the minor, Your Lordship, discrepancies in the procedure. The material whichever they are relying on must be the cogent one, which will directly affect the core of the prosecution case. In such cases, only the 389 application can be accessed, power can be accessed. I will rely on, Your Lordship, para 33, Your Lordship. This was reported in 2023, 6 SCC 123, para 33, Your Lordship. May I read, Your Lordship? Bearing in mind the aforesaid principle of law, the endeavor on the part of the court, therefore, should be to see as to whether the case presented by the prosecution and accepted by the trial court can be said to be a case in which ultimately convict stand for fair chance of acquittal. If the answer to the aforesaid question is to be in the affirmative, as a necessary corollary, we shall have to say that if the ultimately the convict appear to be entitled to have an acquittal at the hand of this court, we should not be kept behind the bar for a pretty long time till the conclusion of the appeal, which usually take a very long for decision and disposal. However, while undertaking the exercise to ascertain whether the convict has fair chance of acquittal, what is to be looked into as something palpable. To put it in the other words, something which is very apparent or gross on the face of the record, on the basis of which the court can arrive at a prima facie satisfaction that the conviction may not be sustainable. The appellant court should not reappreciate the evidence at the stage of 389 CRPC and try to pick up a few lacuna and loopholes here, or there is a case of prosecution, such would not be a correct approach. Here, Your Lordship, it clearly says, not only merely on the lacuna, the court should say. Here, Your Lordship, if they satisfy the court that section 42 and 52 is not compliant with, which is the considered as to be given by this honorable court. In that case, Your Lordship, it will directly affect the prosecution case, Your Lordship. And so far as done the earlier observation, since Your Lordship, there is already an observation in the same appeal. So, Your Lordship, I cannot, Your Lordship, make a distinct submission on it, since there is a clear observation that section 50 and 42 has not been complied with. So therefore, Your Lordship, so far as suspension is concerned, Your Lordship, if Your Lordship has found that there is that the case which they have projected, if directly affect, or if the court find that there is a possibility of the acquittal, then Your Lordship, I will leave it to your discretion, so far as the suspension of sentence is concerned.
But by going by the
Disclosure.
cross evidence of the IO,
Yes, Your
it
Lordship.
has also come to the notice that he did not make any inventory.
Yes, Your Lordship.
That will be also a non-compliance. of
Yes, exactly, Your Lordship. If inventory goes, everything goes, Your Lordship.
NTPS.
This is the thing, Your Lordship. This all are actually, which my brother is projecting, is not a mere lacuna, Your Lordship. The flagrant error has been committed by the investigation authority, Your Lordship.
Your petition will be allowed. I stand disposed of. We'll pass the order. It will take some time to dictate all these quotations will be there. So I'm passing the order in the chamber. However, your petition stands disposed of. We can allowing the petitioner to remain on bail by filing, submitting the bail bond and amount of rupees 20,000 with one security with the satisfaction of the learned patient judge. But an appeal for appeal, I'm going to dictate you I in the chamber, and in the appeal you said that so and so heard as here is not yet been received. For reminder be issued. Appeal be list after 4 weeks.
And Your Lordship, both the appeal may be taken together, Your Lordship.
Other appeal number can you submit an appeal
There in the
number
order,
for-
Your Lordship. 24 of 2023, Your Lordship. Criminal appeal 24 of
No,
2023.
we are on, now we are on I, which item we are on? 21, 22, no?
Twen- Both the matter may be taken together, Your Lordship.
We are on 22. So I dispose I stand disposed of, and other matter, criminal appeal number, yes,
24 of 2023, Your Lordship.
24.
Yes, Your Lordship. 24 of 2023.
The appeal you write, and the matter be listed along with the criminal appeal, connected criminal appeal, cannot connected, criminal appeal 24 2023. List according, after 4 weeks.
Obliged, Your Lordship.
The appeal of bail आहे ना? No, only on unanswered for one. It has not come. Already come. Yes,
May I
23.
Yes, my lord. My lord, FIR is at phase 15, madam.
This is an AB,
AB, madam.
FI is at page
15, madam.
15.
15, 1 5, madam.
Ah.
This is a letter to the SP. This letter has been treated as a FIR and then accordingly cases registered. Married, madam. Married. Subject request to lodge FIR against the promoter of MS D Raju Enterprises ST category at Amchi, Duimuk district, Papumpare, Arunachal Pradesh for availing the grants and aid for their project under the scheme for creation, expansion of food processing and preservation capacity of the Ministry of Food Processing Industry by submitting a fact bank account, bank documents regarding. So I am directed to refer to the above cited subject and to provide the following facts in relation to the project MS D Raju Enterprises. Applicant is the proprietor, my lawyer. ST category at MT Duimuk district, Papumpare, Arunachal Pradesh. MS D Raju Enterprises was accorded approval for grant in aid of rupees 3.10 crore by this ministry letter dated 03/03/2021 Annex 1 under ST category for setting up of a new unit for manufacturing of fresh chicken, canned chicken, smoked chicken, frozen chicken at Amchi, Duimuk district, Papumpare, Arunachal Pradesh under the scheme for creation, expansion of food processing and preservation capacity scheme of the ministry. The said farm got the approval, approval of the ministry and subsequently availed the first installment of grant in aid of rupees 1.55 crore. Sanction letter number so next by submitting post bank documents from Indian Overseas Bank Itanagar branch regarding appraisal of the project and sanctioning a term loan of rupees 160 lakhs. This paragraph is important. The ministry had released the past installment of the grant in aid of rupees 1.55 crore to MS D Raju Enterprises based upon the confirmations from Indian Overseas Bank Itanagar branch on so and so data, wherein it was confirmed that the bank had sanctioned a loan to the project of MS D Raju Enterprises. After receipt of confirmation from the bank, the PM at the Program Management Agency appointed by the ministry conducted physical site inspection of the project on so and so data, along with one Mr. S. Kaising, who was to be the bank representative. However, later on it came to known that Mr. S. Kaising was suspended by the bank official of Indian Overseas Bank Itanagar. Subsequently, Mr. Kole, now the manager IOB Itanagar branch by email dated so and so, has informed that the branch only had current account of MS D Raju Enterprises and that their bank had not sanctioned any loan under the so and so scheme of this ministry. From the email dated so and so of the IOB Itanagar, it became clear that the project of MS D Raju Enterprises had neither been apprised nor been provided term loan for the project by the Overseas Bank. Apparently, MS D Raju Enterprises has submitted post documents to the ministry and got approval for grant in aid of rupees so and so by fraudulent means. Thereafter, MS D Raju Enterprises has also availed the past installment of grant in aid of rupees so and so crore under the so and so scheme, and thus has defrauded the governments of India by submitting post documents.
So your petitioner is the
Proprietor of the funds.
proprietor of MS D Raju.
Yes, ma'am. So, ma'am, what happened here? The allegation is that I have not sanctioned the loan by the bank. But question remains the grant and aid of one past installments that has been used, my lord. That's a manufacturing unit has been constructed and almost 80% of the structures has been completed, my lord. Now, this bank manager, earlier the bank manager, they submitted the documents. I applied for the loan. They submitted the documents and documents was given to this ministry. And on the basis of the documents, the grant and aid been provided to me, my lord. So, my lord,
The question, the crux of the matter is that only that those the documents on the basis of or on the strength of which your loan was being sanctioned, all are false.
False. That's the element, yes, ma'am. Otherwise, the purpose for which the grant and aid has been granted is comply with, my lord. Now, my lord, at this stage, I
But
may,
can a person be allowed to obtain a loan by furnishing some forged or fabricated document? I think it cannot be.
yes,
Your purpose may be, there you have been, maybe you use the say sanction loan for the purpose which you have taken, but that is the issue.
that's true, my lord, and section involved is, my lord, the maximum punishment is 7 years, up to 7 years only, my lord. So, my lord, I may be given some time liberty, I may be given some protection so that I can clarify before the IO, my lord. So CDB may call for, and meantime, I may be protected so that I can clarify and give a statement on 161.
Yes, your lordship, so far as the FIR is concerned, the proprietor is not only involved, many other people is also involved, the banker also, because one of who has been terminated or suspended, your lordship.
Already,
Yes, your lordship, is there in the FIR itself, your lordship.
Suspended, my lord.
And
suspended.
in your lordship.
bank officials also.
Yes, your lordship.
suspended, my lord. One
So,
bank,
it's in
official.
B para, your lordship. Last, however, later on, it came to be known Mr. S. Casing was suspended by the bank officer. From this FIR, it's very clear that the prima facie 420 is made out, and the proprietor in connivance with the bank official, he has defrauded the this Ministry of, your lordship, this food processing industry, your lordship. Whether his purpose is doing pretty good or not, that is immaterial, because but from the inception, your lordship, the prima facie case is made out. But so far as, your lordship, the offenses is concerned, your lordship, when 7 years come, your lordship, Arnish Kumar automatically hit the mind, your lordship, because there is strict guidelines by the Honorable Supreme Court that certain parameter has to be complied with by the investigation authority, your lordship. So, your lordship, at this stage, no doubt, your lordship, anticipatory bail would lie, but 7 years is the punishment, all the sections, your lordship, 7 years. So considering that, expect, your lordship, on strict condition, your lordship, imposing strict condition, your lordship, the protection may be given.
Anish Kumar, etc. will be applicable, this is 7 years.
Yes, your lordship.
under the- But the question is that we anticipate paper how far the protection can be given.
Yes, your lordship.
In my opinion, I have rejected your prayer for interim protection. CD will be called.
Yes, your lordship.
Heart so and so is an application under section so and so, CD will call for fixing.
My lord, Friday, and do you know,
I'm not fixing any date on Friday. I'm leaving.
Maybe on
because of
Monday or
some marginal-
Tuesday.
marginal matters are there Friday, so. it
Lordship,
will
on
be
Tuesday,
Monday.
Monday or Tuesday, your lordship.
Monday or Tuesday.
Okay. Mon-
Tuesday is, no, not Tuesday, actually.
15, your lordship.
If it is,
14.
matter is urgent, then it can be fixed on 14.
14, your lordship.
14.
14 years. CD, your lordship.
6 weeks.
Oblige, your lordship.
Right, yes, lordship.
This is also ABQ.
Yes, lord. Here, the applicant is a breastfeeding mother of 6 months old girl child.
Huh? Huh?
Applicant.
Huh?
Applicant is a breastfeeding mother of 6 months old baby girl.
Baby girl.
Yes. Now, much of the facts in nutshell
This
is
is
that
also related to,
no,
oh no,
no.
APPSC, not related.
No, this is SIC. The matter pertains to that through a social media, some 28 primary teachers were illegally appointed that were surfaced through social media. It was surfaced through social media.
And
Thus-
those appointments were illegal.
Yes, the allegation was that, yes.
Uh-huh.
After that, government of Arunachal Pradesh constituted a 3-member fact-finding committee. That fact-finding committee was treated as a FIR. Now, during this in the inquiry, this applicant appeared. She appeared on 27/7/2023 or 27/6/2023 during the inquiry. She appeared before the investigation officer. She deposed and during inquiry, and now again she's having apprehension because again they're calling the applicant with a guardian.
So how applicant is related? She was
the one of the primary teacher who is said to be illegally appointed.
her appointment is said to be illegal.
Yes, her appointment. That is at page 14. Her name appears at serial number 16. That FIR is a very long FIR, 4 pages.
Okay, now 16, she is 16 number.
Yes, it's in 16 number.
Hmm.
Now,
It is alleged along with the others.
yes,
Her appointment was also illegal.
yes, it is said to be illegal.
Yes, it
Investigation is
alleged.
going on. Now, now she have deposed before IO that from where she got this appointment letter and on what time she joined
Yeah,
her place of posting.
when she received the notice or when she.
No, Rishab was sir. She
No
was
notice
called by
was-
phone, yes. Called by phone and she voluntarily went there and deposed everything before the IO. Now IO, most probably now, we have apprehension that this investigation officer wants a different kind of story. And which is will be self-implementing and that will be in violation of provision of Article 20, Clause 3 of Indian Constitution, where it says that and 161(2) of CRPC, where anything can be deposed, but which is self-incriminating, it cannot be deposed. Now, when I have everything, before I have stated everything from where I got the appointment letter, when did I join, everything is his. During inquiry, everything was his, all my service book, bank accounts, my parents' phone numbers are given, everything I have done. There's nothing left for my custodial interrogation right now. And moreover, she's a mother of 6-month-old baby girl. So I would like to place one very old judgment of 1978 to SCC 424. This is para 19. Here, 1972 SCC 464 or 424. Now, this is some protections are given to the female actual woman married. Before discussing the core issue, we wish to note our regret in this case at the higher level police officer ignorantly insisting on a woman appearing at the police station is a flagrant contravention of the wholesome provision to Section 160, Clause 1 of the CRPC. Such deviance must be visited with a prompt punishment since policemen may not be a law unto themselves, expecting others to obey law. The wages of indifference is reprimand and of instructions disciplinary action. If the alibi is that the session court had directed the accused to appear before the police station, that is not absolution for the police officer from disobedience of law. There is a public policy not complementary to the police personnel behind this legislative perspective, which keeps juvenile and female away from police company except at the former safe resident. Maybe in years later, community confidence and concern will regard the police force as entitled to better trust and soften the stigmatizing or suspicious provisions now read across the court. So, also here, when she have already deposed before the IO, again calling to the police officer without issuing notice and without giving the reason that why she is being called. Now this case is of all documentary nature. The appointment of the she was terminated. It was her. In fact, the DDAC is Deputy Director of School Education. He was arrested, and it was found that after giving appointment, their money were manipulated by them. They were given appointment in 2020 and salary were given from 2022. Even they have raised this dispute also. They have even filed a representation to the school education also, Commissioner of School regarding that. And that accountant and that both DDAC have been arrested. They are in judicial custody now. So in view of, may kindly grant interim bail for me.
May I please, my lord? My lord, it seems like the FIR was registered on 7/7/2013. But it's
Yeah.
7/7/2023 now. And it pertains to a PC Act case, my lord. Here, PC Act, Prevention of Corruption Act case, and it's a very serious crime, my lord. And the investigation has been going on only for 1 month, my lord. It is in a very initial stage. It seems, my lord, may kindly turn to page 15. Okay. I don't have proper instruction as of now, as because, my lord, it is an unlisted motion, my lord. Page 15, my lord. The 4th para, my lord. In fact, the illegalities were circulated in the social media, my lord. And thereafter, fact-finding committee was constituted, my lord. Para 1 to 4, my lord. As for the fact-finding committee, my lord. In fact, they are harping upon the fact that, my lord, they were appointed on the basis of the DPC, my lord, on 28/9/2020, my lord. Madam, may I read it, my lord? As per the fact-finding committee report, fact appointment orders appear to be duly signed by the then Director of Elementary Education, Sri Tapigao. Fact appointments were shown to be made on the basis of the recommendation of the Departmental Promotion Committee held on 29/2020. Names of 28 fact PRT posted in Longding district were found to be in recommendation of the DPC dated so and so. Appointment of 28 PRC in Longding district are fake and illegal. In fact, they say that they are appointed by this Departmental Promotion Committee, my lord. But during the fact-finding committee, it was found that their name does not appear in the DPC, my lord. However, they were appointed, my lord. And the present petitioner, my lord, she was initially appointed to Anjao district, my lord. And thereafter he was transferred to Longding district, my lord. And after the fact-finding committee, it was found that 28 fact appointments were made. In fact, the DPC was not conducted in respect of those 28 appointees, my lord. So it seems as of now, there is a primary case, my lord. And it is in a very initial stage, my lord, of the investigation, my lord. May I humbly pray that at this stage, my lord, giving bail will hamper the investigation, my lord. But as far as, my lord, submitting fairly, my lord, as regards to the child, my lord, that I leave up to this honorable court's judicial discretion, my lord. Yes, my lord. My lord. Otherwise, my lord, I will object to the interim prayer.
Part Mr.
You, Bori. You.
Are you voting the learned counsel for the petition? Also heard Mr. A. Pada, the learned special PP. It is a petition under section. It is an application under section 438 CRPC, praying for grant of pre-arrest bail to represent accused petitioner in connection with SIC PIG police station case number 02/2023 under section 120B, 420, 468, 471, and 409 of the Indian Penal Code, read which section 13(2) of the PC Act. It is submitted by the learned counsel for the petitioner that the present petitioner is innocent, and she's been it is false allegation are brought against him that she is appointed illegally along with the 27 other teachers in Longding district, Arunachal Pradesh. However, it's submitted that getting the information from the investigating officer, she already appeared before the IO and her statement has already been recorded. And even the other relevant documents are already been seized by the investigating officer in connection with this case. Further, it is submitted that she is a 6 months old breastfeeding mother, and hence in such a situation, and hence this present petition has been filed seeking anticipatory bail as there is an apprehension of arrest of police in connection with this case. However, she is ready to cooperate the IO in further investigation of this case if she is allowed to remain on interim request bail. In this context, the learned counsel for the petitioner also regarding the decision of Honorable Apex Court reported in 1978 to SCC page 424, wherein in para 19, it has been observed that the woman appearing in the police station is in contravention to section 161 of CRPC. Next one. It is further submitted that she is a permanent resident of the address locality, and there is no chance of absconding if she is granted with the privilege of pre-arrest bail, interim pre-arrest bail. Next one. In this context, the learned Special PP Mr. Opada has submitted that the FIR was lodged in connection with this case only on 7/7/2023, and it relates to the PC Act, and at the same time, the investigation is at the very nascent stage, and hence at this stage, if the present petitioner is allowed to remain on anticipatory bail, it may hamper or temper the entire investigation of this case. Also, it is submitted that from the FIR itself, it reveals that as part of the fact-finding committee, the present petitioner along with 27 others never appeared in the Departmental Promotion Committee, DPC. However, they were found to be recommended by the DPC, and they all illegally in their appointments, and all the appointments were seems to be illegal, which reveals, which is established privacy in the statement of the FIR. Next, considering this submission made by the learned counsel for both sides, and also considering the gravity of the offense, I do not find it justified to pass any order on interim pre-arrest bail at this stage without perusal of the case diary, and hence let the case CDB call for fixing this. How many will be required? What time? From it has to come from
Itanagar.
Itanagar. So
Today is,
maybe 16th.
we can it be on 17th, my lord, 17th, 18th, my lord.
Huh?
18th.
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 18th of August. This time kind of corruption things is going on very prevalent in, I would not say that this state.
My lord.
These things are happening